Substantial redress at hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. Once such prejudice is established, other factors come into consideration. I want to emphasize the aspect of prejudice to say here we are having an urgent matter because there is a prejudice that the applicant, Mr. Thabo Bester, will suffer. What prejudice are we talking about? Number one, we are referring to the right to a fair trial, Section 35(3) of the Constitution of the Republic of South Africa, Act 108 of 1996. Now, we are also referring to the right to human dignity, which is in Section 10 of the very Constitution I mentioned. And we are also referring to Section 35(3), which is the right to be presumed innocent until proven guilty. Now, when you look at the trailer of the documentary that Netflix want to broadcast, there is so much that leaves, that is left undesired for our client, Mr. Thabo Bester. Why? Because there is somewhere there where it is stated, one of the speakers in the documentary state that Mr. Bester faked his death and escaped from prison, not allegedly. He speaks it as though it's the gospel truth, as though it's absolute. He has got the factual proof to say indeed he faked his death and escaped. And these are the allegations before court. It has never been established. He has never been found guilty at any point. We also have got a challenge with the trailer itself, because we have in the trailer, number one of the co-accused, which is the father of the second applicant, Nandi Pama Guduman. What challenge are we having there? There is a phrase that the father of Nandi Pama Guduman says. He says, "I cannot imagine my daughter doing such a thing." The question is, what a thing?
And how does that reflect on Mr. Bester?
We are coming to that. We are coming to that. Then we have an issue of saying, what is such a thing? Definitely when we speak of such a thing, which the trailer has already suggested, where one of the speakers says, we don't know whether Dr. Maguduman is an accomplice or a victim. Now, accomplice to what? To Mr. Bester, whom already the trailer has rendered him to have faked his death and escaped from the prison, which is not allegedly, it is stated like that. And I will also want to direct the court to the answering, I think the answering affidavit of the respondent, Netflix. There are some interesting things that are being said there that that the court really need to look at them in order for us to be able to find a way forward. When you read the answering affidavit, it's kind of unclear what are they saying about this this documentary. Somewhere there on, let me quickly look at that. Somewhere there on their papers, they say Mr. Best. This documentary is not about Mr. Best. It's not about Mr. Thabo Bester. They state it, but somewhere there, they simply state it clear that it's about Mr. Bester, and then still that is what the court needs to look into. In paragraph 28. In paragraph 28 of the answering affidavit, it says, at paragraph 46 of the funding, Mr. Bester alleges that Netflix is exploiting his life story for financial gain without consent, which seems to be a repetition of his personality rights argument. As indicated above, this rejected, there is no exploitation of Mr. Bester's life story. The documentary focuses on the prison and criminal justice system, as well as broader societal issues about social media, gender-based violence, public safety. This is not this is not Mr. Bester's life story. It is proven this will be a private law claim and remedial through damages. So now they say the documentary is not Mr. Bester's life story on paragraph 28. And I want the court to also look at paragraph 9 of the answering affidavit again. It says on paragraph 9, the Beauty and Bester, which is the subject of this application, is similarly a true crime documentary. True crime documentary. It profiles one of the most notorious events in South Africa recent criminal justice history, the escape from prison of Mr. Bester. The escape from prison of Mr. Bester, who is convicted murderer and rapist. His relationship with famous and glamorous medical doctor, Dr. Nandi Pamaguduman. It is this documentary which Mr. Bester does not want Netflix viewers to see. The documentary was produced by a company trading, this part is not important for my argument. The most important part is that they said this is not about the life story of Mr. Bester. Now here they come on paragraph 9, that this is about the escape from prison of Mr. Bester. Escape from prison. The problem is this. We said we are arguing on section 35, subsection 3 of the Constitution, whereby everybody has got a right to be proven innocent. Everybody has a right to be declared innocent until proven guilty. Now here we have a situation of saying the Netflix, it is putting it as a confirmation, as if there is a judgment that Mr. Bester has escaped from prison. And there has never been any proof that says he has escaped from prison. He has never been convicted on that. And that is what the court needs to look into when it look into this this documentary. And also on that, speaking about the documentary, there is a very interesting aspect that turns this documentary not into a social commentary. It turns it into some sort of a kangaroo court or a quasi court or a moot court, whatever kind of a court we can call it. Because somewhere there is one of the most respected legal person in this country, Judge Cameron. Judge Cameron...
Are you saying Judge Cameron is the head of a kangaroo court?
I'm not saying he's the head of the kangaroo court. I will not even dare to say that he's the most senior. I have to give him so much respect. I'm saying this documentary becomes some kind of... I have never impliedly said that, and I will never say that. And I'm not even creating that impression to the court. What I'm saying to the court is...
Yes.
Permit me to answer, and I will finish my statement. What I'm saying to the court is, we are having Judge Cameron featured in the documentary. The first thing that he says, which is just a line in opening, he says, this is the most improbable thing that I've ever seen as a judge and in my life. Now, Judge Cameron is speaking as a judge and also in his personal life. He is not just there as a commentator. He is there as a judge, and he acknowledges his position. He says, as a judge. And I am saying, or rather we are saying in our application, such makes this whole documentary to take a different turn. Because the moment a former judge who has done so much work, we read so much of his precedents. I have so much respect of Judge Cameron. And I'm saying, him speaking there, talking about this as one of the most shocking stories of his life, it then creates a certain element in this documentary to say, it seems like Mr. Thabo Bester, who is fully a center of this documentary, is already found guilty in a documentary. And why am I saying this documentary is still about Mr. Bester? Because they say the beauty and the Bester. Who is Bester? Is Thabo Bester. Now, we know the phrase Beauty and the Beast from one of the old movies. Now, the Beast no longer exists. Who exists? The Beast has been replaced by Bester. So it means that in the nearer future, we are likely to have a situation whereby when kids are asked, what do you know? They won't say the Beauty and the Beast as we knew in the literature of English ourselves, who grew up during that time. They will say the Beauty and the Bester, meaning that the beast has been replaced by a certain individual. Now we have a beast in person and personified into the person of Thabo Bester. So then this documentary, from its naming angle and perspective, it has already brought what we call a serious defamation to the person of Thabo Bester. And we cannot sit and keep quiet when Thabo Bester, who is my client and the applicant in this matter, is being turned or rather narrated as the beast. Because that's what the documentary suggests. Proceeding on engaging the answering affidavit, my lady. I have a there is something here that is very interesting. On paragraph 27, on paragraph 27 of the answering affidavit of the respondent.
Can you refer me to the page, please?
Let me ask my colleague here for a page. Paragraph 27 page. Thank you. My colleague just assisted me. He says it's 137. Oh, 00005-137. Apologies for the delay, my lady.
Thank you.
I am reading from the hard copies. I'm still functioning like an old lawyer, even though I'm young.
Yes, I'm there.
As I proceed on paragraph 27. At paragraph 28 and 29 of the founding affidavit, Mr. Bester alleges unlawful exploitation of his personality rights. There is no exploitation of Mr. Bester's personality rights. A documentary about an alleged escape from one of the most secure prisons in South Africa is clearly in the public interest. Moreover, this documentary deals with broader issues of global significance, including social media, gender-based violence, public safety. Netflix is entitled to commission such documentary. If there is a course of action based on this, it can be addressed later in civil action. For now, the public is entitled to make up its mind about the prison system is alleged to have allowed a convicted man to escape from a maximum security prison. Now, reading paragraph 27, it creates an impression of saying, this documentary will simply come and say, we have done our research, we have the facts, we have found the truth, Mr. Bester has escaped. But there is no court that has declared, that has made a judgment on that. And if they say the public is entitled to make up its mind about how prison system is alleged to have allowed a convicted man to escape from a maximum prison, a convicted man has escaped from a maximum prison, they are already creating an impression of saying he must be found guilty. And that's where now we are talking about a fair trial right being eroded or violated. And also, my lady, I want you to also look at something that is very interesting here on the very same answering affidavit. On the very same answering affidavit. On paragraph 40 of the answering affidavit, it says, I hope the page will not be a problem this time. On paragraph 40 of the answering affidavit, it says, Mr. Bester's allegation about consent, participation, and approval rights are thus both factual, inaccurate, and legally irrelevant to the relief sought. There is simply no basis upon which a notorious public figure, such as Mr. Bester, can seek censor to censor speech about him, simply because he has not given consent. If this were the law, no speech about public official or public figure will be permissible absent permissible absent their consent. Now, I want to direct the court specifically to this phrase that says there is no simply basis upon which a notorious public figure, such as Mr. Bester, can seek to censor speech about simply because he has not given consent. Now, because there is Mr. Bester who is purported notorious, and this has to be questioned, how do we conclude that somebody is notorious? Is there a measure that Netflix uses to declare somebody notorious? Do we have 1 to 10 to say Mr. Bester is notorious? When you cross the bar of 8 allegations or accusations, that's where you are notorious. Or how did they conclude that he's notorious? And having said that, they still come to say there is no way he should consent. It means that now the right to dignity of Mr. Bester is in question. He has no rights anymore. He can be spoken about as if he's just a piece of meat that has no feelings, emotions, or mind. Then that's where the court needs to look into this documentary as a violation and erosion of human rights. Because if Mr. Bester is notorious and we can talk about him anyhow and have people speaking there and declaring him guilty as if they've got all the facts right and the court has backed their claims, then we are having a challenge in South Africa when it comes to protecting human rights. And also, I want to bring a very interesting point in this to say, you know, the way this documentary has been sensationalized and the vibrations of it, including the emotions created, there is somewhere one speaker on that documentary says, "Are you dangerous?" And they edited it, putting Mr. Best on the other side, saying, yeah, as if he's answering that question that he is dangerous. Now, that is manipulation. That is artistic manipulation. Very wicked craftiness of the editors of this documentary. Because they are sitting there putting stories as if he is confirming that indeed he is a dangerous man.
Where is this in your papers?
Is there in our papers. In my funding papers is there. Is there in my papers. Everything I'm saying is in my papers. I will not waste court time and speak from my mind.
I'm asking you a question, you can just answer it.
Is in our replying affidavit. Is in our replying affidavit.
Yes, because it definitely wasn't in your founding, so it's something new.
Yes, it's... My lady, I didn't get that one. Can you please repeat that?
I said it wasn't in your founding affidavit, so it's something new in your replying affidavit. Where is it in your replying affidavit?
Actually, in our funding affidavit, we do explain about the manipulative editing that this documentary has. And on our replying, we were expounding on that. Actually, our replying, we were adding more meat to what already is being raised in the answering affidavit.
So where is this about Mr. Bester, and then as though he answers yes, he's dangerous?
I'm trying to get the paragraph of, the actual paragraph where this is being actually said. My lady, on paragraph 31.
So are we in the founding or replying?
Is on my replying.
Okay.
It's on my replying on paragraph 31. On paragraph 31. Excuse me, my lady. it reads thus. As argued in my founding affidavit and elsewhere in this affidavit, Netflix has employed crafty and manipulative editing practices in the publication of this documentary, which can also be seen in the trailer where one of the commentators is shown to be asking the question, will you say you are a danger to society? And a video clip of myself is then superimposed after stating something along the lines of, yes, I will say so, or yes, I believe so.
Thank you.
So we have that in our papers. So now this also shows that this documentary simply tries to drive a certain narrative about Mr. Thabo Bester. And now if we have this kind of a documentary being flighted, whereas on the 19th of September, next week, Friday, he will be appearing in court, what is the impression that is being created there? And also, these are type of documentaries that make the public to believe that somebody is guilty. When they are not found guilty, then the judiciary will be looked at with wrong eyes or will have a bad reputation simply because there were some prominent people, celebrities, who were speaking, social commentators, that he is guilty. And this is so emotionally created that it becomes one of the greatest assets of manipulation that you look into this documentary. I saw one of the celebrities, well-known figure, crying. I wonder, why is she crying? What does she know? Was she there? So these are some of the questions that we really look into. And also, one of the impressions that Netflix or the Respondent is creating is to say they are listing a number of articles that have been written about Mr. Thabo Bester. To say it has been written about his rape cases, his Facebook, whatever. They bring many articles that they Googled and they printed them and brought them to court. Now, my question is is that because there has been so much published unfounded without having the actual proof of that, should we allow the further publication on that? Is that how things must be? Because some articles have been written in some newspapers, some video clips have been made on social media. Must we allow also Netflix to do the same? And Netflix has already described itself as one of the giant media houses that says it has got 300 million, how many? 300 million subscribers or viewers. Now, if Netflix published this tomorrow, this documentary tomorrow, just for 1 hour, with their 6-point-something million followers in South Africa, it means that in a space of 1 hour, after this radical marketing that they have undertook with this trailer and this documentary through the trailer, it means that we are going to have many people seeing this, and after to see this, a public opinion and the public court would have decided otherwise about Mr. Thabo Bester. Then when that has happened, the question I'm having is this: are we still gonna have are we still gonna have a fair trial in that regard?
Sorry, are you saying that a documentary will influence a court, a judge?
I'm saying
because I find that quite preposterous. Because let's just take it to the end. A judge can only make a finding on the evidence that's before him, and it can definitely not be on a documentary.
I am saying a right. What I'm saying, which is in my papers, I'm saying a right to be presumed innocent until proven guilty, which is section 35, subsection 3 of the Constitution, needs to be protected. This documentary, I'm answering your question. Allow me a space to elaborate my answer. I will answer you fully, my lady. I am saying section 35, subsection 3 of the Constitution, a right to be presumed innocent until proven guilty, has to be protected, including even with a notorious person as labeled by the respondent, like Thabo Bester. Why? Because should that be, when he is found guilty, we do not know what influence will that be we don't know the amount of influence will that documentary be having in that proceeding. And we are saying such documentaries carry a weight into the public court, carry a weight into the public opinion and interest of the people. And also, my lady, hear my argument within the context of everything that I've been saying for past 30 minutes or so. I have already said, in this documentary, we have the accused, one of the co-accused, who is speaking, the father of Nandi Pamaguduma, and I'm repeating that. And she says, I could not imagine my daughter doing such a thing. It's left there so that people can go and watch the documentary to hear what such a thing will my daughter be doing. And now we also have a judge, Justice Cameron, speaking in that documentary, saying, as a judge, I have never seen such a thing. What a thing is that? Definitely we are talking about Thabo Besta's alleged escape, which already the answering affidavit have stated that this documentary is about that. Now, my argument says, when such documentary are flighted or broadcasted, we then are standing in one corner of the truth, because he is also not given a right of reply. But that is not part of this argument. It's part B of the argument. I'm just saying it in passing because it has to balance my argument. Part B has to balance my argument in part A. So, the court finding him guilty or not finding him guilty, the moment he goes on the street and is not found guilty, because I believe that he's hiring lawyers like us so that he should not be found guilty. He will not be found guilty, I suppose. Then the state has failed to prove his case beyond reasonable doubt. Now, already the documentary has stated some kind of their truth or some kind of their baseless facts to say he has escaped. Now, it means the judiciary of South Africa allows somebody to walk free who has been found guilty by the public opinion. I am addressing the public opinion, and I'm speaking about the fair trial here. And I'm speaking about the right to be presumed innocent until proven guilty. And that cannot be left unattended. Now, having argued all this, my lady, the question is, why are you in court and sweating so much, Advocate Myla? The reason we are in court is because we are asking that this documentary should be interdicted. On which base do you want this documentary to be interdicted? There is a case, as I'm closing, there is a case of Setlogelo versus Setlogelo, which is there on my practice notes. The case has laid down very important requirements for an interim interdict. Number one, it stated that a prima facie right, though open, what is required for an interim interdict to be granted by the court? Number one, a prima facie right, though open to some doubt. That's number one. Number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. Number two, the absence of an adequate alternative remedy. The absence of an adequate alternative remedy. Number four, the balance of convenience favor the grant of the relief. Number five, the balance of convenience favor the grant of relief. Then the last one. Oh, this is me reasoning. This is the fifth one will be the balance of convenience favors the grant of relief. Now, my lady, when you look, when you look at our founding affidavit, the applicant has covered all the requirements set out in Setlogelo case. Number one, prima facie right, we have already stated that there is a right to fair trial, which is section 35 of the Constitution. A right to be presumed innocent until proven guilty, which is section 35(3) of the Constitution. And also a right to dignity, which is section 10. A right to equality, which is section 9. And also number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. There is a phrase we use there to say once the bell is rung and the documentary is flighted, what then will be of Mr. Bester? And people have seen the story, have heard whatever that has been heard. What more will be? Obviously, there will be irreparable harm. After the documentary has played for 1 hour or 2 hours, since they said it's 3 parts, after the first part, they are done with Mr. Bester. He's already guilty by the format of the trailer. Number 3, the absence of adequate alternative remedy. If this documentary of Netflix is not interdicted, my lady, what more will remedy be for him after it has been flighted or broadcasted to 300 million followers of Netflix in 160 countries as they boast? Definitely Mr. Bester, in every corner of this world or planet Earth, he will be known as a man who faked his death and escaped, because we saw it in the trailer. Is there. And number 4, the balance of convenience favors the grant of the relief. I mean, when you read what the respondent says in their papers, they say the reason this has to be played or flighted is because they cannot keep their their followers or subscribers in suspense, meaning their subscribers are more important than the human rights of Mr. Bester. Their intellectual or emotional tickling and their feelings must be created at the expense of Mr. Bester's rights. Now we also have we also have the convenience. The convenience favor the grant of the relief. What more will be convenient for the court except to order an interim an interim interdict? I do not see any possible way except this. And the court must note in our papers, we do not say this must not be unpublished. We say let the trial end and they will publish it, whether he's found guilty or not. They will even have more, because it will have even the trial in it. It will even have this part. So they will have a bigger meat to give to their 300 million subscribers. So now, my lady, I also want to conclude on this case that deals with the specific requirement for prohibition of media broadcast. It's coming from the case of Media Television versus Director of Public Prosecution, which the respondent has labored very hard on it. Here, the Supreme Court of Appeal was asked to prohibit the broadcast of a documentary on the grounds that it might prejudice a pending criminal trial. The Honorable Judge Nugent held that the publication may be prohibited where a prejudice it might cause, 1, a demonstrable and substantial harm. Number 2, where there is a risk that the prejudice will occur. Number 3, that the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, looking into what the Media Television case has brought, we are sitting now, my lady, on an argument of saying, does Mr. Bester has a case that can be decided in line of Media Television case? Indeed, you look at number 1, that a prejudice is demonstrable and substantial. My lady, if one of the accused, father and also the co-accused, and the father of one of the accused says, I could not imagine my daughter doing such a thing. What a thing. I'm wondering, what a thing is there? Definitely it's not talking about her daughter graduating to be a medical doctor. Most definitely it's talking about assisting or doing whatever in this alleged escape of Mr. Bester. Definitely it's about that. And number 2, we are talking about, the case says there is a real risk that prejudice will occur. Once this documentary is flighted, prejudice will occur. What prejudice is that? We can mention close to 20, but for now, I will say, to save time, let's mention 2 or 3. Number 1, we have 300 million subscribers who will be listening to people declaring a man whom the court has not declared guilty to be guilty, who are sure of what they do not know. That contradiction there, they are sure of what they do not know, as if they were there when they saw him escape from a prison. We have that problem now. And we cannot allow that to be flighted, because there is a trial coming. Let the trial decide. After the trial to decide, that will happen. And my lady, this is not the first documentary, by the way. We had documentary of many celebrities with their trials, including your Oscar Pistorius, including your Mudimulle, Monster, all of this documentary after the trial. Why is this one supposed to come up now? Now, number 3, the disadvantage of curtailing the free flow of information outweighs the benefit of preventing the prejudice. Now, there is an argument of saying we are affecting the freedom of expression of Netflix. But the truth of the matter is that we are not. Because this documentary is their investment, they have made it with their money. They can still archive it and do more parts, play it later. It will still be there in their archives. That is their intellectual property right, or their right to creative work. So we are not doing this application to curtail the free flow of information. Perhaps at the time when they do this, Mr. Bester will be granted a right to reply. So my lady, having said that, this brings me to the conclusion of my argument to say, if there is one thing that I will argue the court should do, is to simply grant an interim interdict of this documentary. Allow the court to make a decision on Mr. Bester's case, looking into the constitutional right of Mr. Bester. Number 1, a right to be presumed innocent until proven guilty. Number 2, a right to a fair trial. Number 3, a right to dignity. Number 4, a right to equality and protection of the law equally. Having said that, I thank you, my lady.
Thank you very much. Are we going to let you first answer, counsel?
Yes, I'm happy to answer, my lady.
Or do you want to first talk?
Anything, my lady.
Okay. You have got a microphone. Yeah, I was just worried.
My lady, we are in your hands, but I'm happy to just run it now and then.
I think perhaps we let both of them argue.
Yes.
I think it's going to be easier.
Yes,
Are you
as
ready
you
to
please.
proceed, counsel?
Please, my lady. I'll just seek indulgence to set up. Just to.
Yes, certainly.
My lady, going after Mr. Bester's case, it's not an admission that these cases are similar.
No, that's why we're doing them separately.
Yes, but I'm putting them up front, just obviously for the purpose of convenience. And that is our point of departure. These two cases are markedly different, and I will explain that particular aspect. But just to set the tone and not to accede to the defense by Netflix, I will read a paragraph from the Constitutional Court from Justice Chrysler. It is at paragraph 23 of the applicant's head, Ms. Mabuduman, page 007-12. This is just to set the tone and to privilege this court with the necessary vocab that we are going to binge on and move with it to demonstrate the strength, if indeed this case is decided on Section 35 of the Constitution, ultimately demonstrating the weakness of the respondent's defense, this relying on Section 16 of the Constitution. In other words, they say this case, it's a contest or balancing of Section 35 and 16. We differ from that aspect, but I'm just reading this aspect to set the tone. In that, if we find ourselves there, we are covered by what I'm reading here. And this is what it says in that Sanderson versus Attorney General citation is there on the footnote. So we quoted paragraph 22.
Sorry, where's counsel gone? Oh, there you are.
Yes,
I can't see you.
I'm here, my desk. I'm here, my desk.
I want you to listen. Yeah.
No, I'm listening.
Okay.
As
Yeah.
the court, please smile it. This is what it reads. It's a lengthy paragraph, but you know, just to set the tone, I think that I'm going to read it verbatim. Others, I will assume that your ladyship, as it has been confirmed that these papers have been read. I will suggest in a moment why the fair trial protection of the accused extends to non-trial related prejudice. But my point here is simply that a narrow textual approach of Section 25(3) is likely to miss important features of this provision. That's a previous provision in the interim, which is then now Section 35. The central reason for my view, however, goes to the nature of the criminal justice system itself. There's a mention of a fair trial and the nature of the criminal justice. If we find ourselves in the debate of Section 35 versus Section 16, the double weapon that the applicant, Ms. Magudumana, has is the fair trial right, Section 35, and the administration of the criminal justice system. The harm is on all the citizens that deserve to have public faith in the criminal justice. Then it continues. If in principle the system aims to punish only those persons whose guilt has not been established in a fair trial, prior to a finding on liability as part of the fair procedure itself, the accused is presumed innocent. He or she is also tried publicly so that the trial can be seen to satisfy substantive requirements of a fair trial. The profound difficulty with which we are confronted in this case is that an accused person, despite being presumptively innocent, is subject to various forms of prejudice and penalty merely by virtue of being an accused. These forms of prejudice are unavoidable and unintended by the system. As a practical matter, the impact of a public process on the accused may well be to jeopardize or impair the benefits of the presumption of innocence. While the presumption of innocence will continue to operate in the context of the process itself as a criminal process, it has little force in the broader social context. Trial by public. Indeed, many may pay no more than lip service to the presumption of innocence. Doubt will have been sown as to the accused's integrity, conduct in the eyes of family, friends, and colleagues. The repercussions and the disruption will vary in intensity from case to case. In this one, it's grave. But they inevitably arise and are part of the harsh reality of the criminal justice system.
But isn't he saying that's part and parcel of it?
Yeah, my lady, when someone is setting a tone, must be allowed to do so. I will then elaborate. I'm setting a tone, and what Justice Crickler is accepting that some of the things are part of the system, but we can't shy away from the fact that prejudices are highlighted, and trial does not only happen within the court, and prejudice does not only happen within the process itself. then we say that, and that's a close quote of that particular case. So that means when I get to the aspect of Section 35, with what I've said, then the meat will be fleshed out. So now, dealing with what brought us to this court today, it's an interim application to interdict what is about to be paraded tomorrow, 12 September 2025, by Netflix, working together with Storyscope, pending the determination in Part B. In Part B, we say contemplated proceedings could either be action or application. It will depend on the assessment fully of the facts, whether there won't be any serious dispute of fact when that application is then prosecuted. And the prayers, what is contemplated there is that the respondents, all of them, the respondents, Storyscope, Netflix, contrary to what they do belatedly, they rely on the contractual terms of what is called a licensing agreement to tell the applicant, Ms. Magudumana, that if for any reason you have a right to breathe in terms of the Constitution, that licensing agreement does not allow you to do that, and it also blocks you from invoking that right in court, except if you want to claim for damages. So that particular contract is again public policy, and it will be determined fully in Part B. But this is a problematic aspect. She can't even, we are at the mercy of that contract to even invoke Section 12. We are at the mercy of that particular contract, because the engagement, as I will demonstrate from the letter, when a demand is made first to the first respondent, that is Storyscope, ultimately to the second respondent, Netflix, the theme was the same. You have signed a contract. In terms of the contract, you can't even approach the court to assert any form of relief except the claim for damages. So she is at the mercy of Netflix. And how do they justify that mercy? They will tell you, you've signed a contract. Then, with that said, this is how you then need to categorize this matter and separate it from the first matter that was argued, which was squarely a contest between Section 35 and 16. This one is what we said under the overview rubric. It's peculiar and unique, and that uniqueness has not been appreciated by the respondent. So let me now deal with the aspect of agency. The biggest challenge on agency in respect to Ms. Magudumana, or the applicant in the second case, is an impression that she has created the agency, self-created agency. But there's a timeline accounting for each and every process that was followed before coming to court. Then I'll just take this court through the timeline quickly. But the timeline itself is started paragraph 71 of the founding affidavit, page 001-31. That is where the timeline starts, and then it takes you through until we find ourselves in this court. On the 20th of August 2025, it marks the first event that brought us before this court. That is page 001-117. This is the letter of demand by the applicant's attorney, directed to the first respondent, Storyscope, bringing to the attention of the particular prejudice that might ensue. So in other words, on the 19th Mr. Machini, who's also representing Ms. Magudumane in the criminal trial, came to know about these sound bites. I won't repeat them. My learned colleague dealt with the sound bites and the content, so I won't repeat. He heard for the first time about the sound bite, and it resulted in this letter of demand being sent to the first respondent. My lady, I will presume that what has been pleaded in the founding papers obviously incorporates everything that is there, but it's simply a letter of demand, desist. Do not publish this without giving our client an opportunity to comment, view, and have an input. Not in terms of some natural right, in terms of what is common cause. There is a commercial agreement between Ms. Nandipa Magudumane and Storyscope. So it's quite different from that other particular one. It's not an issue of natural right coming from the air. It's a contractual right that she was also trying to invoke. Then the response from the first respondent, my lady, you will find that at page 001-122. And specifically, I want to direct your ladyship to paragraph 3 of that particular letter, if your ladyship is already there. That is the response from the first respondent. Paragraph 3, it says that, in particular, we will not be addressing any matters that pertain to Dr. Nandipa Magudumane, as Mr. Mgudwa and Mr. Mutlong, who has signed a release on behalf of Dr. Magudumane in terms of the power of attorney, are aware there are existing contractual obligations that apply to Dr. Magudumane. Then in paragraph 4, they say, I must candidly say that the extent to which the information has already been shared with yourself, the legal representative of Mr. Bester, obviously they were thinking that if you were once appointed, you are permanently appointed, in a manner that potentially violates those contractual terms, is a matter of grave concern to us. We reserve our rights in regard. So they say that I urge Mr. Mgudwa and Mr. Mtlong to consider the relevant clauses before further discussion. Is the clause of that agreement that says that she's not even allowed to see the doors of this court. Her section 34 right, she can't exercise. She only exercises at the mercy of the respondent only to claim for damages. Then Netflix, at on 26 August 2025, page 001-125. I said Netflix. This is the letter by the applicant. I want to direct the court to paragraph 9.2 therein.
I'm there.
Having seen the response from the first respondent in the letter that I've just read before, now it was clear that there might be some impasse between the first and the second, but the publishing is going to be done by Netflix. The first respondent is the production company. They have an arrangement. The applicant's attorney requested that they be provided with the information of Netflix so that they can then engage with Netflix, because ultimately it's Netflix that is going to publish this particular aspect. Then there was no response to that. And at paragraph 73 of the founding affidavit, which is then found at 001-32, the applicant asserts that, or the attorney visited Dr. Magudumane in prison for consultation to inform her about what's happening. Remember, she doesn't enjoy the same right that we enjoy. You have to set up a consultation to go to prison, to even give a report. So it's not for the applicant attorney to decide that now we are going to court. After everything that has been discussed, you must still report to the client and obtain necessary mandate. This is the meeting to obtain further mandate in light of what was about to happen. Then, at paragraph 77 of the founding affidavit, it is then recorded that an instruction was given that you can still engage, because Netflix has not been engaged. You can still engage. There is a possibility of this matter not reaching this court. Then you then have a letter on the 28th of August 2025. That is the meeting wherein this letter now is addressed to Netflix, substantially repeating what has been discussed with Storyscope and asking a roundtable meeting so that parties can find common ground. Netflix then responded only on the 31st of August 2025 to the letter of demand. And obviously they reiterate that she can't come to court because of the contractual clause, and particularly at paragraph 6 of that letter, which is found at page 001-136. That is the page number. Paragraph 6 of Netflix response says that Dr. Magudumane has also concluded an archive licensing agreement with our client, in terms of which she agreed commercial terms with our client for the use of her personal archives in the production of the documentary, and that she has waived the right to interdict. She has waived this right that we're trying to do. The right that she has in terms of Section 34 is simply access to court. She has waived it. And the court must endorse that. Because what? Netflix empowers artists in the country, invests a lot in the country, therefore they must be excused from the constitutional supremacy, must move to a capital supremacy. And then she has waived the right to interdict documentary. Obviously, the terms of the agreement are confidential, but the point is made. So, my lady, there's no escape that this matter is markedly different from what you've had in the first application. This is their own terms. You can forget about, obviously, what is then being attempted now in this court to confine it to that comparison. Then, just to move fast now, because we're on the 31st, I'll just summarize what then happened from the 1st to the 5th, in order not to derail this court. From the 1st to the 5th, there was engagement between Netflix and Dr. Magudumane. And particularly, in respect to the roundtable request, Netflix said, we've played open cards, we've placed our version fully, we've told you the limitation of your case, but you are not saying anything. But at the same time, you are requesting a roundtable meeting. Then Dr. Magudumane then paused for a moment that, wait, let's place our version, because it seems like the reservation of roundtable meeting is based on the fact that the other party is playing open cards, the other party is not. Then she then placed that version, that this is my version, on the 4th of September, and gave Netflix an opportunity to respond, failure of which she will approach the court. She gave them an ultimatum until the 5th of September, 2025. Then, on the morning of the 5th of September, Netflix did not just ignore that request. They said, please grant us an indulgence, we want to take further instruction. So they did not say, we have reached the loggerheads. They wanted to consider that particular aspect, and she could not have rushed to court when they saying that we are taking instructions. Only after 3 hours did they then say that now we have reached the deadlock We are no longer engaging further. And that's when now the process of then approaching this court commenced. And they got the unsigned papers on the 7th, less than 2 days, on the 7th of September, unsigned. And then they got the signed one on the 8th. So they knew about the case from the 7th. On the 8th, it's simply the signed papers. And that's how, because of the exigency of the matter, it requires that so that you give your opponent sufficient time. But in any event, even on when a deadlock was reached, they were forewarned about what is going to be sought in court. A draft notice of motion was sent, and then a draft overview that so that you can have a sense of what is going to be brought, so that you are not caught by surprise when you receive the papers, because that is the requirement when you are prosecuting an extreme urgent matter. You keep your opponent abreast. In fact, they even say that we don't appreciate that you are sending us unsigned papers. So they are simply saying that don't even comply with the requirement that you should if you are prosecuting urgently. But they also want to use it, that now you don't even engage. You sit and then you come to court. So I've accounted to the aspect of self-created agency, and I would submit, my lady, that the applicant in that respect have met what is required. Give a reasonable account of what happened, not give the perfect account. This is perfect, but it doesn't say give perfect. Reasonable account is there in ISROP, is there in Mogalakwena. And the requirement is this: once you are faced with an urgent matter, you have two things that you have to do: investigate, try to resolve. I've dealt with the issue of trying to resolve. Investigate, consult with the client, seek more information. In fact, in one of the first letters, the respondent had said that it seems like you are not well vested with this information. You need to source more information, and then she did that. So I closed that aspect of self-created agency. And it also dealt with the issue of whether she will be afforded substantial redress in due course. When is this due course going to happen? Because even if she had elected that the due course is the normal course, wherein you follow the normal rule 6, 10 days, 15 days, heads of argument, practice note, you get a date from the registrar. Here you are the registrar. But in terms of that problematic contractual clause, there's no due course for Dr. Magudumane. It doesn't exist. It can only exist if this court intervene on an urgent basis. That due course will never ever exist. She will not enjoy. Unlike in the Thabo Bester matter, there's no any bar can invoke Section 35. Dr. Magudumane can't. She's at the pocket of Netflix. Netflix decide what right does she have in terms of the Constitution. It says that it's a claim for damages. She's not, if that is endorsed, it goes to the issue of unequal treatment. There's one person in this country that is not allowed to exercise any right in the Constitution, subject to approval of Netflix. That is Dr. Magudumane. Can't be argued that that's unfair treatment if this court is going to endorse that. So she must live with that, with the unknown due course, and with the consequential harm, which is then, remember, if you can approach the court and this documentary is allowed to be published, we then say that these are the further harm. The first harm is that your Section 34 is blocked. But the consequence of that is that Section 35, there's a reasonable apprehension based on those sound bites that my learned colleague dealt extensively, that it will be violated. That's why you say that there's a reasonable apprehension. You don't have to wait for the harm to happen. And if that harm is not going to be redressable, even if there's a remedy, you are entitled to bring it on an urgent basis, because remedy and substantial harm the harm are two different tests. So that accounts for the issue of Dr. Magudumane would not be afforded substantial redress. And substantial redress should not be confused with the defense that our learned colleague raised, that she can't prove the harm. At the stage of agency, you don't have to prove. In fact, your ladyship must assume that a case is good, and we are going to argue that it's good, but here you must assume that a case is good. Then we pass the agency. Then what are we left with now? We are left with the 4 requirements in Sitlogelo versus Sitlogelo of an interim interdict. My learned colleague dealt with that as well, so I won't reiterate the position in law. It's tried.
Yes,
But-
and there's been many cases
Yes.
after Setlogoli versus Setlogoli.
Yes, it's just the biblical reference.
That was, I think, in the 1919,
Yeah, you have
before any of us were born.
that is correct, Wiley. That's why I'm saying it's biblical. So we leave it there, but obviously it gives us, just if you don't want to reiterate those principles, you just simply say Sitlogelo and then that's it.
Now, you actually refer to the latest matter. That's how it works.
And,
So you relate to the latest constitutional court matter on what the requirements is for a final interdict.
It's not. We are not seeking a final interdict, but if your ladyship would have had regard to our heads of argument, in fact, what we did is just to dump Sitlogelo, but the reliance is not on Sitlogelo. It's just to dump it. That's why I say it's biblical. What we then rely on is the constitutional court judgments, actually to invoke those particular rights, and it's there in the heads of arguments. Then the first, it's the city of Tshwane versus AfriForum deals with those particular aspects, the 4 requirements, and we relied on that case at paragraph 21 of the heads of argument. That is 007-12. But my lady, I'm not going to be going back and forth in terms of which case must I use to invoke a particular requirement. A requirement is a requirement. Prima facie is a prima facie. In fact, I can just demonstrate that she has a prima facie right to Section 35 without even referencing to any case law. Section
But then
35
you're
is
not
the law.
completely correct in saying that it's completely distinguishable, the 2 matters, because you're also relying on Section 35.
I'm saying that as an example, I've dealt with Section 34. The entry port, I say Section 34. What then follows is that the violation of this text, the block or the bar to approach the court is Section 34. So she can't even enter. She can't even speak about Section 35. Section 35 then, it's impacted on 2 aspects. If it's blocked in terms of Section 34, then it's a consequence. But if it's not blocked in terms of Section 34, let's say there was no limitation to approach the court, then she would then exercise Section 35 in 2 respects. She would then say that in terms of the arrangement that we entered into, we agreed that this documentary will not have any impact on my pending criminal trial as a contractual right. If that contractual right falls off, then we are at their terrain. 35 versus 16, their favorite terrain. But there are many terrains before we get there. That's
Sorry,
what
I don't understand your argument.
It's simple.
No, listen, let me rephrase as I understand.
Yes.
And then you can tell me how simple
As the
it
court
is.
pleases, my lady.
So you're saying because there's a contract that says that denies her the right in 34, you can't argue 35 today. Is that your argument?
Not entirely. The
Well, then
consequence
tell
of
me
that.
the simple argument.
Yeah, the consequence of that. So let me simplify like this, my lady. First, let's remove the bar of Section 34 first,
Yes.
right? Even if there was no bar of Section 34, because Section 34 was simply to say that she can't even approach the court to assert any right, including Section 35. So it can be violated as long as that bar exists in any other right. But if that bar is uplifted,
But she's before court today, so why can't she argue 35?
yes, but
And in fact, as I see some of your papers, you are arguing 35.
But that's what we are arguing, but we deal with the peculiarity, my lady. If, because I can't blindly argue. I must argue based on the case that is before the papers. The case that is before the papers, it contextualizes the case, and we say this is unique. Because if we jump to Section 35, then I'm saying that we are being dragged to the terrain. The respondent creates their own case and says it's our case. Our case is not a Section 35, but that's a consequence of what is happening prior to that. It takes us there, either because of the bar or the removal of the bar. But I won't stress that case any further. I'll just then proceed with that, because even if it's similar of this commercial arrangement, forgetting about the Section 34, there are peculiar circumstances. Then, my lady, the rights that I dealt with, that as a consequence or not of Section 34, those are the rights that she has. And for now, she only has to establish that she has a prima facie right to that, even open to doubt. And the peculiar aspect, which it's a matter to be dealt fully in Part B, and I want this to be captured. Absent the constitutional right that she has in terms of 35, 34, 9, 10, she also has what she says is the true intention between the parties in this commercial arrangement, and not what has been reduced in writing, which is also against public policy. She says that in terms of the Boots principle, in Part B, she's going to ask the court to give effect to the true intention of the parties and not merely accede to what has been reduced in writing. So if she succeeds there, which we say that she has a reasonable prospect of success, then her right that she has now in this particular instance is that before Netflix or Story Production produces the documentary, she has a right to view, to comment, and provide input. And this one that they are publishing, they've denied her that right because they are relying on the stricture of what is written. She is then saying that there's problem. Public policy, alternatively, it does not reflect the true intention of the parties. And I'll get to that aspect of the intention of the parties. But I don't want us to derail, because I'm just inviting the court to take what is called in our law a judicial peek. You look at, just uplift the veil of what is going to happen in Part B. You assess whether there are reasonable prospect of success, and then you say this is a good case for prima facie. Then, irreparable harm. The Sanderson case that I started with, it just summarized the grave harm that will be suffered. But drawing it closer to Dr. Magudumane's case, the right to remain silent is that you have a right to even walk out after the criminal case. If the state lead a palpably weak case, simply don't say anything, you leave. State has closed the case, fine, I'm leaving. And then you can be discharged even if you're not saying anything.
You can also be found guilty if you don't say anything.
Yes, but my lady, the point that I'm making, you can also be, I'm not saying that there are no other possibilities. I'm saying that you can also be released, not excluding other possibilities, but I accept you can also be found guilty. But the right of the presumption of innocence means that you can also keep quiet, and then you run the risk of what your ladyship is saying.
That's actually the right to silence.
Yes. Then this right to silence, this is now I'm taking closer to the favorite terrain. Meaty. It's a Supreme Court of Appeal judgment.
Has it got meaty in its title?
It's repeated. It's repeated. When you go to the heads of argument, meaty. Second paragraph, meaty. 3 paragraphs, meaty. Yes. So because it's meaty. If you are going to then say that the fair trial right are going to be impacted, there's a reasonable apprehension that they're going to be impacted, the standard is high. The harm that you are apprehending must not be far-fetched and too remote, must not be speculative. You'll see in the heads of argument, because it's going to be repeated. That I can guarantee. Meaty is going to dominate the argument. But meaty is not excluding that you can't prove it. It simply says that the standard is high. Then, in meaty.
So are you saying the court doesn't have to look to meaty? Or
No,
what are you saying?
meaty establishes a principle that I've said. Meaty says that for you to demonstrate that there's a reasonable apprehension of harm in terms of the child, that's a principle. The standard is high. That's a test. the facts that you are relying on must not be too remote to the harm you're apprehending. That's the principle. So we are also relying on it. Because that principle does not say that you can't prove it, or it's impossible. It doesn't establish an impossible test. Then now, in MIDI, firstly, that's a principle, it applies to everyone. But there's also market difference from MIDI and this particular case, and we've dealt with that under the overview in the founding affidavit extensively, in anticipation that MIDI is going to be relied on, because we were informed of MIDI from the point of engagements. This weapon has been there, and today it's going to find manifestation for the last time. Maybe it's the end of the MIDI documentary.
So you say I can overrule MIDI?
No, my lady.
Oh.
My lady, I've been saying that MIDI establishes the principle. What I'm simply saying that it's used as a weapon. We're also using it as a weapon. But this weapon has been carried from the letters of demand, response, and today is going to find its manifestation. And then that manifestation is going to fall on Dr. Magudumani's side, on what we are going to say now. But we first have to distinguish MIDI. This is an application by an accused in a criminal trial. She has not pleaded to the charges. An accused person, co-accused, in terms of the sound bite that my learned colleague dealt with. Put a statement that when you look at it, there's a reasonable apprehension that Dr. Magudumane's trial is starting tomorrow, full force. What is going to happen on the 19th of September would already been subjected to a public trial that Justice Krikla spoke about. Tomorrow, people, in terms of the soundbite, are expecting to see the trial. Then what is the impact that it would have, which is not remote, to the right to remain silent, and the presumption of innocence? It's that in the absence of this dumping of this version of the co-accused that must have impact on the co-accused in a common purpose crime, she would have enjoyed this right fully, without fear of what might possibly and reasonably implicate her is published by Netflix. Then now, what would then happen is that, can she reasonably enjoy, based on the apprehension, that right to remain silent? And you must accept it from this point of view. If that information is dumped tomorrow, then we know of what we don't know. I don't know anything. We know of what we don't know. That information might also be available to the NPA. I'm not saying it's untoward, but I'm saying it might be available. And it's not an act of God. It's an act of an accused person who's charged for common purpose and the manipulation of the commercial agreement. Now, she might, there's a reasonable apprehension or possibility that she might have to then say something based on what would then be said. And that is what MIDI says. It's not an impossible test. You can't reasonably, in terms of the tone that I've set in curricula, that this is the impression that the people will get, and that information is then available. And why in MIDI failed? In an instance wherein witnesses were also not interdicted to take interviews or for a documentary to be published, is this. Those witnesses were state witnesses. And it is the state, it's the NPA that was trying to interdict. Just
I read the matter, so I know the facts.
Oh, yes. Thank you, my lady. So I'll just accept that that distinction is noted, that it's not an accused, it's the NPA, and there are market difference that I've already said. So the conclusion that was reached in meeting should not be jumped into. Must look at what I've just said in relation to linking it to the fair trial right. And I won't take it further than that. I'm saying that it's not an impossible standard. And this is one of the cases that should at least reach that particular standard. If this one does not reach it, then the test of media would have been elevated higher than saying that it must not be remote. And this is not remote with the tone that I've said in terms of curriculum. Then now, we then deal with the issue of alternative remedy. Prima facie, harm, and alternative remedy. What is the remedy? The remedy is not that if we are on the terrain of Section 35, it's not that you're going to be exonerated. That's not the remedy that she's seeking. She's not seeking exoneration before this court. She's not pleading that I'm not guilty. There is another remedy, not an alternative remedy that she's seeking, and it's not on an agent basis. We rely on the Supreme Court of Appeal because it captures this aspect properly. At paragraph 1725 of the heads of arguments, you'll find the heads of the arguments, applicants' heads at page 007-14. We quote it. I will read only the bolded parts that then explain the test for alternative remedies. It's not just any remedy. It says that, firstly, the purpose of interdict is to put to an end the conduct in breach of the applicant's right. I've dealt with that. Secondly, the existence of another remedy will only preclude the grant of interim interdict where the proposed alternative remedy will afford the injured party a remedy that gives it similar protection to the interdict against the injury that is occurring or apprehended. Then it then says that the fact that one of the parties or even the judge may think that the problem would be better resolved or can ultimately be resolved. It's not a bar or it's not a test for alternative remedy. There is no remedy. What would happen would not undo the harm that Netflix could have done tomorrow. Even if she's not only crying that I must be exonerated. Obviously, there is an impact on that, but other rights that I want to pit myself, my lady. Then now, balance of convenience. And this is the important aspect. You'll remember, my lady, when I started constitutional supremacy and capital supremacy. Commercial supremacy, constitutional supremacy, section 2. So you have to then look it from that prism. You are balancing the constitutional supremacy and the commercial supremacy. They went at great length about the things that they've invested. Stakeholders, people that are waiting to watch this documentary over the protection of the constitutional right. So this cannot start on the same scale. Section 2 says it's supreme. If you want to balance the violation of the constitutional right against the supremacy of the Constitution, put the rights up, put the commercial interest down, then they have to say more, contrary to then now the belated defense. So the commercial interest is not based on their right to publish. It's not a right to publish when you're telling us about the job you create. Then the last aspect is vice versa, 35 and 36 now, in answering what they've created as a case. That answer itself is provided by that particular aspect of MIDI. Because MIDI, when it provided this principle, it was trying to navigate.
Sorry, are you saying the defense is not based on the right to free speech and all of that on 16? Are you saying it's just on commercial?
I'm saying that the case that we brought here is that, and the letters, they say that you can't access all other rights, including Section 35, because you are barred to approach the court. So they are not saying that you can't access that because we can't protect you, we must balance against Section 16. They are saying that in the letter that I've read between Storyscope and Netflix. you are barred from coming to court, which will then affect also Section 35. But I've been saying this consistently, and I don't think that this time is going to be missed. Saying that even if you take out that particular aspect, then you can still be within the terrain of Section 35 and 16. Is that an accession that this case is about? No. But I say that even if you take us to that terrain, my lady, we come out clean. We come out clean. Because MIDI, the principle is navigating between 16 and 35. When it established that principle, that's a navigation. How do you navigate the violation of 16, which is also dressed with some commercial interest and prejudice? Because that's what they say in the balance of convenience. Then MIDI, I won't repeat, but it takes us there. Then the last aspect, in every interim interdict that you contemplate on bringing or you have brought Part B in the same proceedings, the court would also have to take the pick of Part B. I've dealt with the pick of Part B in respect specifically of public policy. I focus on the aspect of public policy because this is what, if your ladyship would have regard to our heads, the preamble says the following. The preamble of our heads is at 007-2. That is the quotation from Barkhazen. I won't read it, my lady, it's known. But it simply says that the court has no difficulty whatsoever to declare contracts contrary to public policy if where their tendency is to restrict or prevent a person from vindicating his or her rights in the court. The court will not hesitate. In fact, it has no difficulty. Contrary to MIDI, the court has difficulty. The Constitutional Court, in terms of a clause that is against public policy and specifically limiting the Section 34 right, it has no difficulty. A standard lesser than MIDI. Then what are other aspects that you need to look at after, if it's not against public policy, just as a judicial pick? I list them from paragraph 33 of the heads. That is 007-16. This is what it says. There are these issues of, it's common cause that an agreement was entered into. It's not debated. What is debated? Don't put it to public. The public should not see it. Hide it. And we've hidden it. But then, now, that contract having been entered was entered into before the authorization of the power of attorney. So what then happened is that, as a summary, my lady, because I want to conclude, I've been here. Dr. Magudumani was approached by a person who claims to be an expert of fundraising and propose a fundraising plan to fund the litigation and say that, you are a currency, you can sell.
Yes, I think the merits of Part B you must do in one sentence.
Or in one sentence,
your
okay.
heads, because I'm not deciding.
You don't have to
You're
decide.
just telling me I must take a judicial pick.
Yes.
That's what you're saying, your argument.
Yes, that's a judicial pick. But, that judicial pick, you take it on this. Let me just enumerate them, because my lady is saying that I must not dwell into much, but I was not going to dwell too much, but it gives context. Let me just summarize them. Firstly, the licensing agreement was entered into before the signing of the power of attorney, and the power of attorney did not ratify such, and that was acknowledged by the respondent in the correspondence. Secondly, the agreement itself, which despite them saying that it's confidential, they took a part and dumped it in the court papers, which is then public. So there's something that is confidential. We're still at the mercy of them. What is confidential, what is not? This one is not. It's dumped here, it's here. The public is going to see it. It has signatures. It has people that put signatures. There are two pro forma blank spaces. Acting on behalf of
You're still not summarizing.
Yeah,
I get the point. The point is that I must look at that there's prospects that the power of attorney was signed only after that.
That's not all.
But then get to the next point, because
The-
I've told you now. On the merits of Part B, I understand what you say. So just shortly summarize them.
Then that summary is simply that the contract was not signed by the authorized agent. Yes, I'll put it there. To the extent that it will be ventilated, I will respond. And then the last one, we had dealt with the issue of public policy. That is the sum total of our case, but I just want to check. My
said
learned colleague has put some note. Yeah, he's saying you're doing good. Thank you, my lady. That then concludes the case. And my lady, I accept the curtailment of Part B, but I will reserve the right if and then there is some investment into
You're
time.
not saying anything to me about the costs.
My lady, firstly, we should not have been brought to this court. This could have been resolved. She was not saying that it must be interdicted completely. It's just trying to find common ground. Then she was put to trouble. She came to court, but in any event, the court should follow the order. If she wins, and then if she doesn't, my lady, even though it's not written, but it's common cause that in the judgment of Judge Wilson, in one of the instances that she had sought to invoke Section 35, in exercising his discretion, Justice Wilson was sitting in Johannesburg. He said he considers the fact that both of them, Mr. Bester and Dr. Magudumani, are in prison, so it would be unreasonable to mulct them with cost. If indeed, I'm not even going to attempt that. It's not a bio watch, but I'm just saying that this is the ethos, the spirit upon which he refused to grant cost against them, even if they lost, as the court pleases.
Thank you very much. The court's just going to, I'm sorry, before you get on your feet, take a 15-minute break. We will be back at 12. Court will adjourn.
Do something like that. The second statement comes from Judge Cameron, who says that this is one of the most astonishing things I've seen as a judge or as indeed a person. And then the third statement comes from the commentator in the documentary, who asks the rhetorical question whether or not Ms. Makudumana is an accomplice or a victim. The claim that is made is that those three statements mean that the fair trial rights of Ms. Makudumana and Mr. Bester will be vitiated. If we start with the first statement, the statement from the father of Dr. Makudumana, who says that I cannot imagine that my daughter would do something like that. It's actually nonsensical to claim that that statement implicates Dr. Makudumana in anything. If anything, it's an exculpatory statement because the father says the allegations are just not believable. And there's no statement there that says that she is guilty of anything. If we go to the second statement by Judge Edwin Cameron, the statement is simply that it's the most astonishing thing that he has witnessed in his life, or indeed as a judge. That again is a neutral statement. It does not implicate anyone in any wrongdoing. And then we go to the third question from the commentator or the narrator, who says that rhetorically, is Ms. Makudumana an accomplice or a victim? Now, what our learned friends are saying that you must read into that it implicates Mr. Bester. But it simply doesn't. It's a rhetorical question whether or not she is an accomplice or a victim. All of those three questions will be dealt with in the trial. So when you look at the content of the statements themselves, the content of the statement is neutral. It does not implicate anyone, and it doesn't suggest that there is a statement of guilt in whatever manner whatsoever. And then they also say the problem is that Mr. Sikeleni is a co-accused. But that is also an irrelevant factor that he is a co-accused. The fact is that he is making a statement to express his astonishment that he cannot imagine that his daughter would do something like that, which could in fact be interpreted as my daughter is innocent because she is not capable of doing something like that. And then you also hear that, well, Judge Cameron is a judge. In fact, in Mr. Bester's application, the statement is made that he's a judge of the High Court, so they didn't even bother to do a due diligence there. Judge Cameron does not say that anyone is guilty. He just says he's astonished at the facts that he has uncovered. And we know what facts he uncovered because he uncovered facts in his capacity as the inspecting judge of prisons. And he presented those facts initially to the media to ground up, and then secondly to Parliament. And those facts are now widely known. And the facts that he uncovered showed that there had been an audacious escape from prison, and that Thabo Bester had been involved in faking his death. So those are facts that are generally known, generally published. They don't suggest that anyone is guilty of a crime that will be dealt with by the trial court itself. And then the last statement, which is, well, is she an accomplice or a victim? That again is a question that is a reasonable question to ask in the light of what is known. Now, what is also important when one is dealing with these statements is to understand that not only are they notorious, they have also been the subject of judicial pronouncements. And I would like your ladyship to have regard to our heads of argument, where we cite the judgments. It's from paragraph 46.1. Yes, at, all right, doesn't seem to be numbered, but 00816. Oh, 00816. So not only are these facts generally public, they are also the subject of judicial commentary. The first judgment at paragraph 46.1a is a judgment of the Supreme Court of Appeal delivered on the 16th of May 2025. That judgment described Ms. Magudumana as having been a fugitive from justice. It also gave the following summation of the facts at paragraph 2 of that judgment. The appellant, and that was Ms. Magudumana, was at some stage at least the girlfriend of the convicted and sentenced rapist and murderer. You will recall that there was a complaint about those words, but they come from a judgment, that he's a rapist and a murderer. Thabo Bester, who was serving his sentence at the Mangaung Correctional Center in Bloemfontein. And then look at what happens next. Before his escape from that facility in about May 2022, several suspects linked to that escape were arrested and are facing charges in the Bloemfontein Magistrates Court, including defeating the administration of justice, violating a body, aiding an escape from prison, corruption, and arson. The appellant, that's Dr. Magudumana, is one of those suspects. And look at how they deal with this. So they've said Thabo Bester escaped from prison. And again, you know, this is a serious court. We are all adults. The man was serving life in prison. He got out of it. He was not released by the system. So he escaped. I mean, let's not play around. And then when they talk about Dr. Magudumana, they say she surreptitiously left South Africa. And you remember what had happened is that she left the country without using her passport, and that is what is in the bail judgment. Some months later, she was located in Tanzania and brought back to South Africa. And when she was found in Tanzania, she was with Thabo Bester. Before her arrest in Tanzania, the appellant was a fugitive from justice, and a warrant for her arrest had been issued. She subsequently appeared before the Bloemfontein magistrate, who authorized the warrant for her detention at the Bizama Kate Correctional Center in Kroonstad. So that is all facts summarized by the Supreme Court of Appeal. It would be astonishing if the media were prohibited from repeating these facts, which is what that documentary on the parts that have been quoted is suggested to imply, that the man is an escapee and that the lady has aided and abetted the escape. And then it goes even stronger when you look at the outcome in the bail appeal. We deal with that at page 00817 at subparagraph B. Now this was when Ms. Magudumana applied for bail, and the High Court had rejected the Magistrates Court had rejected the bail application. Now, what's important here is to look at the actual judgment of Jordan by Justice Jordan AJ, because it also is actually, yes, it is it's at page 004/180. That's where it starts. What he says about what had happened, I want to just refer your ladyship to a couple of passages. The first is that there is evidence from the investigating officer, which is cited at 004/186, paragraph 11. And this is what the investigating officer found. It says, in this regard, the evidence of the investigating officer started off with him stating My investigation revealed that accused number 1 was promised 7 million rands to orchestrate the escape. He enlisted the assistance of his accused, that being accused 3, 6, and 7. He later further testified on the charges that in count 3, the offense is in contravention of section 3B of the Act 12 of 2004. I think that's the Corruption Act. That is corruption. The applicant and her co-accused acted in the furtherance of a common purpose. Their aim, and that includes Ms. Makutuman, was that Bester must escape. The objective evidence of a bank statement shows that the applicant was also on occasions a source who provided the money to accused 1 for distribution to their co-accused. So Ms. Makutuman took the cash, he distributed it to the officials at the correctional facility. So far, it has been established that the applicant paid 85,000 rands to accused number 1. That's Ms. Makutuman. Then the following passage, they cite the crime of corruption. That's not relevant. We don't have to bother ourselves with that. And then later on at page 004/190, paragraph 17, at the end of that passage, this is what is stated. It says, in this instance, there was no admissibility challenge. In other words, the admissibility of the evidence of the investigating officer, founded upon convincing evidence calling into question the admission of the evidence of the fingerprints evidence showing that the appellant claimed the body of the deceased at the mortuary. So her fingerprints was found at the mortuary, that she had actually claimed the body. The witness statements and the documentary evidence. This court cannot find any misdirection in this finding of the court of quo. And if you turn over the page at paragraph 19/004/191, it goes further. It says the judgment was in ground 11 of the notice to appeal assailed that there was no evidence that accused number 1 was offered millions, and he arranged for accused 3, 6, 7, 8, and 10, and 12 to assist. In this regard, the evidence of the investigating officer in his affidavit started off with him saying, my investigation revealed that accused 1 was promised 7 million rands to orchestrate the escape. He enlisted the assistance of his co-accused, that is being accused 3, 6, and 7. The court did not misdirect itself in finding that there was such evidence submitted. Then it goes further at paragraph 21. It's in the same vein. That's where it says, the court had in contrast the evidence of Colonel Flynn, who stated that the appellant was found in Tanzania, that's the appellant here is Ms. Makuduman, on the 7th of April, without having used her passport to cross the various borders to get there. In this regard, there is also a statement of a witness which states that the appellant, under false pretenses, requested her passport, which was found by the police in Tanzania. The affidavit of the investigating officer further indicated the various means that the appellant made to claim the body, which was to be used to facilitate Thabo Bester's escape. In the process, even making use of the legal process to facilitate claiming the body as Thabo Bester, and requesting an interdict against the police. So she was so brazen that she came to court to try and force an interdict to claim this body falsely. The state contended showed that the appellant is a flight risk with no regard for the law, and no bail condition would have any effect. The fact that she was able to enter other countries without having her passport stamped shows her know-how of how to evade being traced. The appellant's behavior challenging her return is contrary to the behavior expected of a person kidnapped, and she never in all of this time took steps to report same, thus according to Colonel Flynn, calling her kidnapping into question. Now when they conclude on this, they conclude on all of these portions I have cited at paragraph 24, where he says, the court had regard to the evidence that was presented by the state that the appellant vacated her house that she was renting prior to leaving. Her movable assets were removed, and no evidence from the appellant's side of what happened with her property, in the face of the state evidence that she removed it prior to leaving. The car which the appellant rented was found outside the borders of the country. Her own car was not used. I think the charge was that it was found in Zimbabwe. The appellant submitted evidence of a friend offering her an alternative address. There was no rebuttal in regard to this evidence of the state. this evidence was considered by the court a core in making its conclusion. And then look at what happens next, and this court cannot fault it. So all of these were presented in the bail hearing. The magistrate accepted them as being sufficient for the purposes of denying bail. They were then affirmed by the High Court in the appeal. So both the Supreme Court of Appeal and the High Court have made very clear authoritative statement of fact about what the evidence is right now. Now, it would be absurd to say that the media cannot repeat. The media is not repeating the findings of guilt. It's repeating the conclusions that have been reached by judicial officers who were entrusted to look into the bail and to look into the so-called irregular arrest of Dr. Maguduman. And the three statements that we looked at the beginning all fall under the categories that have also been endorsed by the judicial pronouncement. So not only has these issues been judicially pronounced, they have also been the subject of extensive media coverage. And when I say extensive, I don't exaggerate. And I'm not going to quote these articles because they're not as crucial as the judgments. But I want just to refer the court to where they appear. So there's a BBC article of the 20th of April 2023, which is at 005/89. It's entitled Thabo Bester, the South African rapist who faked his own death to escape prison. Then you have another one from the Conversation at 005/98, entitled Thabo Bester's escape from a privately run South African prison raises questions about corruption. Then you have a Ground Up article, and Ground Up was the pioneering news outlet that ran with the story. You have that at 005/102, which explains why we investigated the Thabo Bester story. Then you have the City Press at 005/105, how Thabo Bester was arrested and released by shady cops shortly after his prison escape. And then you have again the Ground Up at 005/111, Police Minister confirms Thabo Bester was detained and then released while he was on the run. And then there is then a fuller article also by Ground Up at 005/117. That article is actually important because it sets out all of the evidence that was uncovered by Judge Cameron, which was then presented in Parliament. And it details it in sequence about what the Judicial Inspectorate found, and that you will see at 005/117. So what you are dealing with here is this story has been written about so many times. It's captured the attention of the judges, and they have made findings of fact on it. And so this documentary that we are talking about today is probably an insignificant piece of this puzzle. And it does not introduce on what has been alleged here anything new. It simply repeats what is already out in the public. And the story of Judge Cameron has been repeated so many times. And the question that is asked by the father, I can't imagine my daughter to do this, would be asked by any parent, and that will not imply any guilt. And the question whether or not Dr. Magudumana is a victim or an accomplice is a legitimate question in the light of all of these facts that I have illustrated. So that then answers the one question about what is known about the story and what is the new angle that has been introduced. It then comes back to the debate, what are the judges going to do about this? The judges that will hear the trial of Mr. Bester and Ms. Maguduman. There we rely on the Arthur Brown case. Your ladyship will recall another notorious criminal called Arthur Brown. I think he ran a pyramid scheme. We've referred to that case. It's one of the first in our bundle of authorities, which is at 019/4. It's very important because what it says is that when a criminal suspect goes to court to say, I don't like the way the media is portraying me, because that's going to influence the judges, which is what we are dealing with. We've got two criminal suspects. They say, well, I don't like the way this documentary is portraying us, because that will influence the judges. What the High Court has found in the Brown case is that you should reject that argument, because you must presume that the judges are independent. They are not going to be influenced by the media. You'll find that at paragraph 105, and this is what it says: the presiding officer is a trained official who knows the justice system and who is impartial when he or she is sitting in their official capacity. A judge is a person of high integrity and honesty. Judges take an oath when they are appointed to uphold the law and to administer justice in an appropriate manner. Then again at paragraph 109, quoting the Bangalore principles, the principle relating to impartiality states that impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but to the process by which the decision is made. A judge shall perform his or her judicial duties without favor, bias, or prejudice. Should a judge find himself or herself in a situation where they are not able to be impartial, then the principle states that the judge will take the following steps, and those are about recusal. So the Arthur Brown case is then determinative of how would a media narrative, as it has been called in this application, impact on the judge. And again, one must distinguish between what the public thinks and what a judge thinks. A judge is insulated from public influence. The Section 35 right is about what the judges will think. And there we've relied on the Arthur Brown case. The other case that is obviously determinative is the media television case, which has been referenced already. What that case really is about, it just says in paragraph 19, that look, if you have a scenario in which a criminal accused comes to court, they try to stop a publication in the form of a prior restraint, which is what we are dealing with here. Firstly, you should not allow them to speculate about the harm. They need to demonstrate the actual harm that will eventuate. The word that is used is will eventuate, not might eventuate, but it says will eventuate. Now, they can't do that here because the three statements that have been cited are neutral statements that don't implicate anyone. Number two, there are already judicial outcomes that have been pronounced on the issue. Number three, there are already a number of articles. And then number four, most decisively, a judge is trusted because of integrity and impartiality. They are able to separate out the noise from the facts. So that's media television. And then there is another case that we found, a case of Manda Manyatse versus Mail and Guardian, which is to the same effect. It's also a Supreme Court of Appeal judgment. I just want to see if we'll find the reference now. So paragraph 19 and 20 also makes the same point, that if you have a criminal accused who tries to interdict a publication on a prior restraint basis, the judge should not lightly grant that. The judge must ask, in what way will this impact the judge, bearing in mind what we know about judicial independence. So that's then media television, the Arthur Brown case and Manda Manyatse case, I think are decisive on this point. Yes, the case is Manyatse, Manytshe versus Mail and Guardian. It's 2009 ZASCA 96. It's published on the 17th of September 2009 on Safli. And then the relevant paragraphs is 19 and 20. So the law is pretty clear on this. No speculation, no conjecture. Demonstrate the actual way in which a trial will be impacted But in doing so, you must bear in mind that a judge is trained and has a forensic mind and will not be influenced by the public. So that takes care then of the Section 35 complaint. You then have a second complaint, which is what about defamation, that the documentary basically defames us. Now, it is an impossible argument to run. Thabo Bester is a rapist and was sentenced to life. And he is also a murderer. The fact that the documentary repeats that he is a rapist and a murderer cannot defame him. Now, there is a fact that has been established by the Supreme Court of Appeal that he escaped from prison. So that cannot, if you report that he escaped from prison, because paragraph 2 of the Magudumana judgment says that he escaped from prison, that also cannot defame him. And he does have a remedy if he has been defamed, and the remedy is a damages claim. And then you ask yourself, what is the defamation to Ms. Magudumana? It's just no defamation whatsoever. Then you have a third claim, which is the claim of equality. This is a bizarre argument because it's not clear, because the starting point for equality is the comparator. It's not clear what they're comparing themselves with, because they're not saying we're being treated differently to other criminal accused who are similarly situated. They can't claim.
I'm not sure I heard any argument on that. Can I just hear, are you proceeding with the equality argument? Can I first hear from him, perhaps? Okay, you're on your feet.
My lady, truly speaking, there are a lot of certain things that are being said that we didn't say, but I was reserving that for reply, because every time I'll be on the stand saying that this is not what we are saying, so there must be a distinction between what...
I'm asking you a simple question.
Okay.
Are you proceeding with equality?
Yes.
Are you?
Yes.
Okay, thank you. You, counsel, because I didn't hear anything in argument.
Yes, we are proceeding. We still maintain the reason that we brought forth before this court.
It's based on equality. One of the
one of the prima facie rights we are raising is we are speaking about is right to equality.
Okay, thank you. Yes, then you'll have to answer.
Thank you, Manette. So, I mean, the short answer is that there's no prima facie case based on equality, because the first starting point in equality claim is a comparator, and they cannot draw any comparator. In fact, what's happening is that Netflix is treating them precisely the same way it would have treated any other subject of a documentary. Then there is a next argument, which is a dignity argument. That again was not mentioned orally, but it seems to be tied up with defamation and the fair trial rights, and the arguments I've made on defamation and fair trial would equally apply. The next one is about consent and approval. Now, they seem to suggest that they have a right, effectively, to veto the documentary. If they said no, the documentary wouldn't be published. But there is no subject who has any entitlement to veto a story about them, particularly a notorious figure. Otherwise, if you started giving people the right to veto a story, no adverse stories would ever be written about anyone. Then you have an issue about prior comment. There is no right in South African law of defamation that a subject of a story is entitled to comment before the story is published. And no right is established here at all. What has happened is that Ms. Magudumana has distorted the contents of the agreement and suggested without any evidence that it gave her the right of veto and prior comment, but it didn't. But she was, in any event, invited to comment. She was invited to give her own story on the documentary, and she elected not to, but she was specifically invited. Your Ladyship will see I just want to get the correspondence on this issue. Those letters of August and January. Yes, I think I found them. So yes, Your Lordship will see at 004/195, 196, 197, 198, and 199. And what you will see is actually interesting at 004/195. Now, this is the time when the documentary was being made. And a fellow called Mr. Bonelela Mkudlwa, who is an attorney who acted for Ms. Makuduman, wrote the following. Hi, Neil. Neil is the filmmaker, the documentary maker. Compliments of the new year, and God bless the journey ahead. Please be advised that Nandipa is finally going to speak and address a few things she and her legal team are comfortable for sharing on the recorder. This is a welcome development. However, she is not prepared to do it before the payment of the last payment is done, which is ultimately only meant to be paid later on for archives, which this recording would be classified under. So she can't now come around and say that I never had a chance to comment. She was given a chance to comment. She promised that she was going to comment, but in the end she elected not to comment. Thabo Bester was not given a right to comment. He has no such right in South African law. Then you find then the last of the arguments is a Section 34 argument. We have dealt with this in full at paragraphs 62, 63, and 64 of our heads of argument. It is an utterly irrelevant. Yes, they are at 00824. So the first thing that is said in relation to Dr. Makuduman is at paragraph 62, where it is said that even if Dr. Makudumana were to succeed in Part B, she would not be entitled to the relief that she seeks in Part A. This is because she has not established any right for such relief. This again demonstrates why there is a disjunct between Part A and Part B, rendering the interdict sought in Part A final in effect. Thus, whatever the fate of the licensing agreement, that has no bearing on the right of Netflix to broadcast the documentary. Its entitlement to broadcast the documentary does not flow from the agreement, but from Section 16 of the Constitution. So it is utterly irrelevant to the case today. Whether the licensing agreement is unlawful or lawful is irrelevant to the entitlement of Netflix to publish the documentary. In any event, your ladyship has put the question. Ms. Makudumana is in court today seeking an interdict. No one has stopped her from seeking an interdict. No one could stop her from seeking an interdict. The fact is that she's not entitled to the interdict under South African law. So the Section 34 point is a hopeless argument. Now, those are all the alleged prima facie rights, and I've tried to demonstrate that none of those prima facie rights have any legal purchase. Then I want to address the question of irreparable harm. Now, the nature of the harm, in accordance with all of the authorities from outer until the more recent authorities of EFF versus Godan, a case that your ladyship had initially decided here, and then your ladyship's judgment was endorsed at the Constitutional Court. Is this when one is dealing with harm? It's harm in the context that if you don't get the interdict, you cannot get any remedy. That's the harm. Now, in a defamation case, they will get the remedy because if they are right, they will get damages. So there can be no harm that is irreparable. So they never actually address the availability of damages. And all of the cases like Midi TV, Manyatse, Brown, they make the point very clear. Damages is the preferred route when it comes to a defamation case. Why? Because an interdict against a defamation impacts Section 16 directly. It's not only the right of Netflix to publish. Section 16 also gives the right of the public to receive information, which an interdict then stops. So there is no harm that is not remediable, certainly not in the sense of EFF versus Godon. Then we are left with a balance of convenience. Now, my learned friend has distorted the argument by claiming that there is the argument to be had is a commercial convenience versus the constitutional rights. I don't know where he gets that from. The case that has been made by Netflix is that it is exercising a right under Section 16 of the Constitution, and it is also protecting the rights of the public to receive information. So the alleged argument was not made. It is obviously a factor that it has made a commercial investment to the production of the documentary, and it has done so with the knowledge and participation of Ms. Maguduman in circumstances where she was paid for the use of her archive material. And it is therefore unacceptable for her at the last minute to turn around and say, I don't know what you are doing. What she has actually done, she was represented by Mr. Mgudlwa, who signed the power of attorney, and Mr. Mutloung, Machini Mutloung. In her founding affidavit, she criticizes them and blames them because she's now found a new attorney. But she has not terminated their mandate. They are still her attorneys. She blames them for all of the negotiations and the contract, etc. And they signed that contract under legal advice, and then now at a later stage she's turned around and changed. So we submit therefore that it's fair for Netflix to say, we worked with you along the route, we are now ready to publish, and you should not be allowed to stop us from publishing. Then the last element is the absence of alternative remedies, and we've already spoken about this in the context of harm. They've got a damages claim and they don't answer the damages claim. That then takes us to the question of urgency. I just want to spend a little bit of time on this. When it comes to Ms. Maguduman, and I'll deal with them separately, we need to look at the facts holistically. On the 8th of January 2025, if your leadership could have regard to page 004/197. On the 8th of January 2025, Mr. Machini Mutlaung, who was at the time the attorney for Ms. Maguduman, wrote a letter to the documentary makers, an email, and this is what he said. He says, I have been informed by Thabo Besta's legal team that there is a clip doing the rounds involving the documentary in which Dr. Magudumana's father is being interviewed. And then if you skip the following second, third, fourth, and you go to the numbered one, he says, I have the following serious concerns regarding the above. Number one, the recording of Dr. Magudumana's father without his legal team giving permission on the content is prejudicial in many respects. Number two, we specifically requested that any interview that is to be conducted in the name of our client should first receive our consent, particularly the content of such interview. Number three, we specifically requested and agreed that no part of the documentary should be shown before the current legal cases involving our clients are finalized. So that was the demand that he made on the 8th of January 2025. That demand was then responded to by the documentary makers at 004/196. on the 3rd of February 2025, in which at the end of that page, it was made clear the following. I can also confirm that the interview with Mr. Sekeleni, that's Ms. Makutumana's father, was conducted in accordance with the relevant releases and in consultation with the legal representative of Mr. Sekeleni, whom Bonelelo had referred us to, Mr. Ryan Ishmael, and such an interview will be used accordingly. So the fact is, as early as the 3rd of January 2025, they knew that the demands that they had made, that they want to comment before the documentary is released, that they don't want Mr. Makutumana's father to be interviewed, and that they would like the documentary to be played after the trial. Those are the demands they made. They were rejected on the 3rd of February 2025. Now, the documentary makers continued, of course, because a demand has been made by an attorney, it's been rejected. Nothing happened until the 20th of August. And why did things change on the 20th of August? It is because the trailer went out. But if you want to seriously think about when did the agency in this case begin, it began as early as the 3rd of February 2025 when the demands were rejected. Then they waited for 7 months without doing anything, without demanding access to the documentary, trying to stop the documentary, nothing. They then come out of the woodwork on the 20th of August 2025. And the letter now is coming from Dinana Reid, no longer from Mr. Mutlowung, and that you will find at 005/62. Now, Ms. Dinana Reid introduces herself at paragraph 2 there as representing both Thabo Bester and Dr. Makutuman. And then she says, I act for Thabo Bester or Tom Kwana. She says I act for Tom Kwana.
Counsel, please repeat the page number.
005/62. Oh, sorry, in Bester's case.
Okay.
Yes, I think that's why. In the Makutumana case, it's 001/63.
Thank you.
Yes, thank you. So if you go to paragraph 2 of that, she introduces herself as acting for both of them, both Ms. Makutumana and Mr. Bester, and says for Ms. Makutumana, she is instructed on bail and civil matters, and then goes on to make various demands. And paragraph 7, paragraph 10, and then paragraph 12. All of the demands that subsequently made it to this application are then repeated therein. These are then rejected the following day by Willem de Klerk attorneys, who are the attorneys for the documentary maker. 21 August 2025, and that you will find at 005 maybe I should use the Bester, 001/68. Yes. But those demands are then rejected. And you will go to paragraph 12, you will see there that insofar as your letter contains demands by Bester, same is rejected. So by the 21st of August 2025, both Ms. Makutumana and Mr. Bester know that the demands that they have made about the documentary have been rejected. They don't go to court immediately thereafter. Instead, a different attorney now comes to the scene on the 22nd of August 2025. And now that is the current attorneys of Mr. Bester. That is, I think it's Courage Morero and Mwekets at Annexure AA4, page 005/70. And they asking for what is called a cease and desist. And then there they make it clear that they will institute legal proceedings. That is on behalf of Mr. Bester. But we know those legal proceedings are not instituted immediately thereafter. Those legal proceedings are instituted only on the 29th of August. Having first demanded that they would be instituted on the 20th, rejected on the 21st, demanded again on the 22nd, but they then wait for another 7 days before they institute those proceedings. And the problem with that is that the period they then give the respondents to answer is a very truncated period, which is not commensurate with the time that they took to initiate proceedings. So that would then become an instance of self-created urgency. You waited too long, even if you had any rights. You just took too long to come to court. They also created a further problem, Mr. Bester's attorneys. The practice manual in this division, it requires all the pleadings to be finalized on the Thursday at 12 o'clock for a hearing on the following Tuesday at 10 o'clock. But they put in the notice of motion that the answering affidavit should only be submitted on the Thursday at 2 o'clock, leaving no time for the replying affidavit, no time for heads of argument. Now, the reason why we raise this, we're not trying to nitpick. If you're going to run an urgent application, there are three players you must think about. The one is prejudice to the opponents. Number two is courtesy to the judge. And then number three is compliance with the rules. What they did, they ignored compliance with the rules. They were discourteous to the judge that's hearing the matter, and they ignored prejudice to the respondents. They basically just did as they pleased. Nevertheless, Netflix took the view that it has a documentary on the 12th that it wants to flight. It does not want this documentary to be held up because Thabo Bester's litigation strategy is clear that it is not expeditious in its nature. So it is going to answer as soon as possible. So it will file an answer earlier than required, and it will file its heads of argument earlier than required. What happened here is very odd. We filed our heads earlier than the applicants. Applicants came with their heads later, which comes back again to the fact that you are running an urgent application with total disregard of your opponents, and with disregard of the rules, and with disregard of the judge. Now, the same applies to Ms. Maguduman. I have already shown the judge that Ms. Magudumana's attorney, Machini Mutlaung, already told us on the 3rd of February, on the 27th of January 2025, what his demands were. Those were already rejected on the 3rd of February. Nothing was done. We then get on the 20th of August a letter written on behalf of both Thabo Bester as well as Ms. Magudumana, making certain demands, which are rejected the following day on the 21st of August. The papers are not instituted at all until the 7th of September. From the 21st of August until the 7th of September, giving Netflix, in effect, 1 day to respond. 1 day to respond. They are told by Judge Mudau that your case is transferred to Pretoria, ensure that you get a case number. They spend the whole day without getting a case number. And they cannot explain why they didn't get a case number for the whole day. Thereafter, they don't file a replying affidavit. It should have been filed at least yesterday. In fact, the directive was that make sure that everything is done the day before, so that, and the reason again is that second element, courtesy to the judge. The judges in this division are very busy. They have many other cases. So you have to give them at least a day's courtesy to read the papers. The replying affidavit came to us last night at about 11 p.m. It was unsigned and it had many ellipses, those dots, incomplete and unsigned. The heads of argument, I saw them this morning. And this is why we say to your leadership, whatever your leadership thinks about the merits of this case, this is a classic instance of an abuse of process, of two litigants that are going to litigate the way they want, according to their pace, according to their rules.
Jonah? Sorry about that, my pen's dried up. Yes, you may proceed.
Thank you, my lady. So the manner in which the litigation has been run has been in disregard of the rules, discourteous to the judge, and in disregard of the prejudice to the respondents. Now, we have been in this situation before. You then have to look at how have they responded. In other words, how have they explained themselves? What you find is the most astonishing thing, where they are so blasé in their explanation. They say it's very difficult to consult with Ms. Magudumana. She's in prison. She doesn't have the rights like all of us. But it is her who decided to bring an application. So when she brought the application, she knew that she had the constraints of being in detention. And there are no excuses that people that are in prison must litigate according to different rules. They must litigate according to the same rules. But the important issue is the blasé nature, the devil-may-care attitude that they bring along when they have to explain. When we have been in situations like this, your client has come to you late, and you know that this is a big problem for the judge. What you do, you become candid, and you explain yourself forthrightly. What you don't do is the arrogance that they have exhibited. Now, this is why we then say, when you look at the conduct of the attorney in running this litigation, it's the kind of conduct that warrants a punitive cost. And you know what they said, my lady? They said that you have to look at what Judge Stuart Wilson did in the case of Showmax. Judge Wilson didn't grant them costs there. What they were trying to do is what they're doing here now, which is to interdict a documentary about themselves and this daring escape. That is not a reason not to give costs. It's a reason to give costs, because it means they don't learn from judicial pronouncements. They've been given a leeway by Judge Wilson. And notwithstanding that, they have abused that leeway that they have been given by Judge Wilson. So which means that this is now the point at which the judges stop giving the leeway and actually stamp their authority over these litigants. So, my lady, the case should be struck, both of them should be struck for lack of urgency. The costs in relation to Mr. Bester should be costs on scale C. Mr. Bester must pay those costs. The costs in relation to Ms. Magudumana should also be costs on scale C, but we ask your leadership to seriously consider a de bonis cost order. And I don't say this lightly, because attorneys are also officers of the court. They bear the obligation to assist all of us to litigate in this court in a dignified way. Thank you, my lady.
Thank you very much. Reply? I'm going to let him reply first because he started.
I'm also requesting a comfort break, my lady.
Okay, we will adjourn for about 10 minutes then.
As the court
We'll
pleases.
adjourn.
The issue of saying the litigant litigate according to their own ways or as manner as they wish, in a manner as they wish. I firstly want to bring this to the attention of the court, which a reasonable man test must apply. My client, Mr. Thabo Bester, he is currently in CMEX. Number one, to see him, you have to make a phone call booking. And that booking is subject to availability of 3-room space to consult. If not, you will not be able to see him. Meaning that if I want to see him tomorrow, I can be told to come the following day. If I have another court case like today, I can't go before 2 o'clock, then eventually we fail to meet. Now, that also will affect how things must be done. The fact that they must apply the rules is exactly what we try to do. That's why at some instances we filed some papers, I think replying affidavit unsigned. Why was it filed unsigned? Simply because we could not meet him to sign it. Because when he has to sign a paper, it must pass through the head, the commissioner of this prison here in Nkosi Mampuru, which will take us 2 hours for us to get it back. Now, my lady, the data are as follows, to show that we acted promptly and as per the agency as it requires. Number one, the letter was sent by my instructing attorney, Morero Mweketi attorneys, on the 22nd of August. When the letter was sent on the 22nd of August, was requested that it be replied to on the 25th of August. And nothing was done on the 25th of August by Netflix. On the 26th of August, that's where now we issued the papers, the court papers for this application that we are arguing before you, my lady. Then on the 27th of August, that's when Netflix replied. Now, there is an assumption that my learned colleague raised to say there was a first Eastwhile attorney and later on there was another attorney. The truth of the matter is that the attorney that was instructed to file this application by Mr. Thabo Bester was Morero and Mweketi attorneys, which wrote a letter on the 22nd after consultation and demanded reply on the 25th. Nothing happened on the 25th as per the letter. On the 26th, they urgently lodged an application. Then on the 27th, that's when Netflix replied. So, my lady, having said that, I want to bring the court to the attention of saying, in all this, the consultation still has to be done in a most difficult manner in which it is limited to certain working hours at CMEX, whereby things are not easy for the instructing attorney to be able to consult. On top of that, having said that, I had my learned colleague saying they filed heads of argument before the applicant, which is true, and they did that. Why? Because even to appoint an advocate, a counsel to argue this matter in court, is still a procedure of consultation with the very same man who is behind bars in CMEX. We cannot ignore that fact. It has to be taken into consideration when we deal with this on agency. That's why I was only personally able to consult and properly get to understand what is required and agree even on financial instruction. At a later stage, that's when the practice notes and the heads of arguments were filed. So that is an issue that needs to be looked into. Having said that, I will conclude on agency to say we have acted promptly. We have responded to this matter as agency requires and demands. And we cannot begin to say there was any better way we could do this. This was the utmost action we could ever do, looking into the circumstances that our client find himself in. And let me go into the reply to some of the merits that my learned colleague, senior counsel, addressed. There are two that he never addressed, two most important issues that he never addressed from the trailer. Number one, he never spoke about manipulative craftiness edited part, whereby a question was asked, will you say you are dangerous? and a voice or an image of Mr. Thabo Bester is brought, responding, say, yeah, I think so, I believe so, but agreeing that it's dangerous. That aspect was never addressed, number one. Number two, the other aspect that was never addressed when he was here is that he never spoke about a fact that there is one who says he faked his death and he escaped. That is one of the most important commentaries from the trailer that should have been addressed. And we really needed to understand if that is not affecting Section 35 of our client. Now, let me speak about this. Judges have a significant role, most definitely, to play, and therefore they cannot be influenced. They are insulated. Definitely, I believe in the independence of the judiciary as a legal practitioner. Even if the judges are independent, but the witnesses are not independent. Witnesses are human beings of emotions. There will be witnesses in this trial who must speak the truth. Once they saw the documentary, definitely they will be influenced or moved to a certain thinking or perspective. The concern is not, when we look into the interest of justice, my lady, we don't just look at the judges. We also look at the witnesses who are assisting the court to reach what we call a justifiable conclusion that is fair based on the mosaic evidence presented before the court. And these witnesses who will be speaking will be exposed to this documentary. We don't know which direction will they take after to watch the documentary, or how will they be influenced by the documentary. That must be taken into consideration for the interest of justice, my lady. And there is this phrase that was spoken that Thabo Bester cannot be defamed because he has escaped from prison. He cannot be defamed because he has escaped from prison. My lady, anyone can be defamed. As long as you are a human being, you have a name, it can be defamed. And my lady, we are trying to cap the wildfire that is already burning the image of Mr. Thabo Bester. We are saying, let us not allow another documentary that will bedevil him, that will turn him or label him as a monster. Having done that, also going to a trial, there is this statement that he escaped. My lady, there are many ways to come out of prison, which it should be proved in trial court. There are many ways. We don't know if he got a parole. We don't know if there are many ways to be released out of prison. It's not always an escape. I am saying presumably he got a parole that will be proved in a trial court. It's not always a case that he escaped. And you know, something interesting that we need to address, my lady, to say this documentary is about prison escape. If really is about prison escape, I'm expecting Ananias Mate in it. I'm expecting there was another one who escaped, Moses something. There are many people who have been escaping in prison, especially here in Pretoria. There are many. I represented some who escaped from prison here. I expect them in this documentary. So to show that it's not about escape of prison, why is it not encapsulating all the escapees that are within the borders of the Republic of South Africa or in any prison? Rather, it focuses on one single individual, that is Mr. Thabo Bester. So that shows that this is not about prison escape general documentary. This is specific to the life story of Mr. Thabo Bester that we are fighting against. Now, my lady, there is also an issue that was raised by my learned colleague to say Thabo Bester was not given a right to reply. There is no right to reply on our law. I have written something, we have written something beautiful here with my learned colleague on our answering affidavit, on our replying affidavit to say, on paragraph 42, what we have titled as right to reply. On 42.2, It says, I submit that even though Netflix is currently not required to comply with BCCSA standards, it is common cause that ethical documentary standards ordinarily make provision for affected person to be afforded an opportunity to comment or tell their side of story. On paragraph 42.6, it says, I believe that had the legislative envisaged the existence of streaming companies such as Netflix when drafting a BCCSA policies, he would have included the necessary provision requiring Netflix to conform to the provisions of the BCCSA. In the absence of same, I am asking the court to intervene as to oversight has allowed the respondent an opportunity to act in a manner that violates my constitutional right, which opportunity Netflix has taken with both hands and at all full speed. My lady, this case that I'm arguing before you is one of the most important cases in our legal system, because we do not have any case where a podcast or some online broadcasting company needs to be given a responsibility to give a right to reply. It is in this case that we will see whether the court realizes that freedom of expression needs to be balanced with a right to reply. Because also a right to reply, it's still included in the freedom of expression to say you cannot speak about me without me replying. I heard that one of the parties here was given a right to reply, but we were never given a right to reply. Mr. Thabo was never given a right to reply. If he could have been given and denied it, that was a different case. But nonetheless, no right of reply was given. So also, in so saying and doing, that also affects his right adversely, because he should have a right to reply. So having said that, my lady, I will say on the right to reply, we do not expect Netflix to abide with the Broadcasting Commission standards of South Africa, because Netflix is a Netherlands company, but we cannot also allow Netflix to come from Netherlands to violate rights of citizens of this country. Because should we allow this broadcast to proceed? We are simply saying an international company can come and violate the rights of our people. I am sorry to say this, but I will have to say it because it's in my mind. We are also having another Jan van Riebeck coming in a camera form, rather than a gun this time. My lady, I will proceed. When we are dealing now with an issue of, a documentary being flighted, we are speaking specifically of saying the damage that Mr. Bester will suffer in this regard is the one that says if he wins a case and he comes out innocent after a trial, where will he live? Who will he talk to? How will the public be viewing him? And what will the media be seeing him as? We are saying let the trial proceed and end. Whatever that needs to be said, it be said in court. Then it will come out clear into the public. With this documentary, will never oppose it. I want to close my reply. Let me check at one point here. I've addressed the right of reply. I've addressed agency. I've addressed harm. Let me labor a little bit on harm. It's very important. Irreparable harm. There is a very beautiful case that we have mentioned here in the on paragraph 43, what we titled this irreparable harm, 43.2, the case of print media versus Minister of Home Affairs, where Constitutional Court considered whether prior restraints on publication, though classification before distribution, were constitutionally permissible. The court recognized the prior restraint is generally viewed with suspicion in our Constitution order. That's paragraph 63. However, the court affirmed that prior restraint may be justified where publication poses demonstrable and substantial risk on prejudice. That cannot be remedied after fact. That cannot be remedied after fact, paragraph 66. The court stressed that the adequacy of alternative remedies must always be assessed in light of the nature of threatened harm. So the court stressed that the adequacy of alternative remedies must be always assessed in light of the nature of threatened harm. So a threatened harm and then the alternative remedy. My lady, according to my learned colleague, he says, let's flight this broadcast, 300 million see it. Who will pay Mr. Bester? We would have made our millions. That's what he says in simple terms. We would have made money, we'll pay him. That will be a substantial redress. The question I'm having, my lady, what is the price of a man's dignity? How much does a man's dignity worth? 5 million, 3 million, 30 million? That is a question we cannot answer at this stage because a harm is done. When a harm is done, there is no money that can retract it. He can be given money, drive in expensive cars, stay in a beautiful house, but the bottom line is that he has already been labeled an escapee, he has already been labeled a fake death host, he has already been labeled all these things. And that's what the court needs to look into. And my lady, there is something that I've learned about. There is somewhere on the papers. I'm not sure which part of the papers of the respondent, but I will speak anyway. I think they are speaking about where they say they cannot postpone this broadcast. It's in their company policy that they can't postpone this. It must proceed. My lady, they have postponed in the past. I will show you. On our answering affidavit, paragraph 44, Netflix history, we title something there, Netflix history of postponements. Number one, in 2014, Netflix postponed and ultimately cancelled Bill Cosby comedy special and Bill Cosby 77 following widespread sexual assault. They did postpone or cancelled. In January 2025, Netflix delayed the release of Meghan Markle's lifestyle series, With Love. Meghan, in response to devastating Los Angeles wildfires, explaining that's the show actually, that during 2023, WGA and SAG-AFTRA strikes in USA, Netflix postponed multiple films, Damsel, Lift, Players, Spaceman, because the circumstances prevented a responsible release. Finally, in COVID-19 pandemic, Netflix delayed numerous production and stage release schedules worldwide. So, by having said, given 4 or 5 cases that I've given of postponement, Netflix does postpone. So even the Thabo Bester, the Beauty and the Beast and the Bester, the Beauty and the Bester documentary can still be postponed for the trial to end. Why is this one is so special that it can be postponed, but others were postponed successfully? And my lady, let me check here if I have something to say. But let me check quickly. I think I have something here that I must make a submission of before I sit down. My lady, let me say this. With a very serious attempt to differ, that you will differ with me perhaps if I say this. The right to freedom of expression must be balanced with the interest of justice. The right to freedom of expression must be balanced with the interest of justice. If the freedom of expression works against justice of others, we need to look very strongly at that freedom of expression. Having said that, my lady, this becomes the end of my reply, as the court pleases.
Thank you. Yes, counsel.
As the court pleases. My lady, I'm going to try to be brief and structure the reply. And the structure of the reply It's simply just tick the issues not dealt with. And then I'll deal with the distortion of what we didn't say and what certain things that were said about certain letters did not say. And I'll also highlight the section 9 and pass on it because your ladyship invited us. And then I will deal with the delayed agency, left to the last.
No,
so
I
that
didn't invite you. I alerted you to the fact that you didn't address it.
I will respond to that. And then I will deal with the issue of delayed agency. Last. In the issues not dealt with, nothing was addressed about what we say, the true intentions between the parties to the contract, which is not disputed. The true intention is not that of which is then reduced in writing, and we made out a case for that, for court to draw inference. One of the inference that we draw is the letter that was relied on. This is the letter, my lady, I hear people whispering, it's disrupting me.
I'm sorry, I didn't hear.
Yeah, it's coming from this side, perhaps they will not continue. Yes. Then now, it's going to be addressed by the letter so-called the right of reply, and not even contextualizing how did Dr. Magudumana know about that particular letter. So I submit that issue of common understanding was not addressed. And the reason it was not addressed was to lump these cases of Mr. Bester and Dr. Magudumane in that they don't have a right. We accept that you don't have an inherent right, but we did argue that the case of Dr. Magudumane is different. She has that particular right, and at the point of this application, which is a prima facie, which is an interim, she must only demonstrate that, even if it's open to doubt, she explained that particular aspect. And this takes me then to this particular letter that when she made an allegation, she gave an history in the founding papers of how she met Mr. Mgudlwa and how she instructed Mr. Mgudlwa and specifically Mr. Machini with the power of authority. None has the power of authority than Mr. Machini. Then she says in the papers, the common understanding between the parties, which is then the true intention that the court will give effect to in Part B, is that she will have a right to reply. And you can't say that in the air. You put facts. Then the facts we say are confirmed in this particular letter that is attached at page 001-37. This is the letter of Netflix on the 31st. Arguing that, okay, actually we have given we say that your client doesn't have that right of reply, but in actual fact, we have given your client a right of reply. And what they do, obviously she doesn't have a WhatsApp. They attach WhatsApp of Mr. Mgudlwa and their representative. They want this court to draw an inference without any basis that it actually reached Dr. Magudumane. This is the question that was supposed to be sent to Ms. Magudumane for her to comment. And Mr. Mgudlwa, in the WhatsApp text that are posted here, never confirmed that he took in fact, he undertook that he will take these questions and he will hear what would Ms. Magudumane say. In this WhatsApp text, none lends to this conclusion that it reached Mr. Magudumane. There was an attempt from Mr. Mgudlwa, but this never reached Mr. Magudumane. And there's no evidence that can controvert that. But what is important, you craft a letter to try to achieve something, you achieve a different purpose, which is fatal, self-inflicted wound. In that particular letter, there is Annexure A, the letter on 001-37. There is what is called Annexure A. And that's why we're saying that you look at what Dr. Magudumane is asserting. The common intention that you must give effect to is that I have a right to reply. They are not coming to this court and say that does not exist. In fact, they act contrary to what they are saying now. They try to give effect to the true intention that they entered into with Dr. Magudumane. Their agent says the following. Dear Bonelela, that is Mr. Mgulwa, as per our previous discussion, we are conducting due diligence on all archives provided to us in accordance with our archive license agreement and have started the process of production legal checks more broadly. Engaging with the person that you have no obligation to engage. Production legal wants us to afford Dr. Magudumane the opportunity to comment, their own words, on certain public domain alleged storyline we may report on. Before we report, we would like to discuss the theme we intend to cover and seek inputs from this. You come to court with almost boldness and alacrity. You say there is no common law, there is no law that confers anyone, Mr. Thabo Bester, Mr. Magudumane, Dr. Magudumane, in terms of your own letters, you are literally recording the intention as you understand it between the parties. Then this is what is important now. We propose the following attached request for comment on the 25th of September, which will not be in the form of specific question we would have otherwise like Dr. Nandipa. Should you find any topics uncomfortable to address due to the ongoing trial. So that is at the center of this arrangement. It's not just fluffed up in this particular letter. It's at the center. Or any other reason, she's obviously free to refrain. That's the spirit of the parties. You will then engage. If you don't say anything, then we don't have that information. Your trial right in terms of the arrangement is protected. Then I conclude with this one. Our intention, which intention? Story scope. Our intention is not to compromise Dr. Magudumane, but to comply with legal requirements for clearance, both locally advised, and they speak about other things. But this is at the center. And when you look at these objective facts, remember, now when you then look at what is the true intention between the parties, you don't choose one side. Say, Dr. Magudumane is saying this, Netflix storyline is saying this. In terms of the Boots case that we've relied on in the heads of argument, I think that's the last paragraph. You looked at this objectively. These are the objective facts before you. Are you going to ignore objective facts and you give effect to a one-sided contract that does not reflect what the parties agreed? That would be a legal absurdity. Then I've dealt with, and this was the letter that was, in the submission it was said that it proves that she got the right of reply. This is the letter to Mr. Mgulwa. Mr. Mgulwa is not Dr. Magudumane. In the letter that, obviously, I won't read the body of the letter, but those WhatsApps, it's efforts. Mr. Nel kept on asking, when are you going to see Dr. Magudumane? I'm still trying. Follow-ups and follow-ups. There was no, I've seen her. This is her attitude. She has seen the question. Dr. Magudumane then confirms in the founding affidavit that the first time that I saw this letter that was addressed to Mr. Mgulwa was on the 31st of August when the instructing attorney showed her that particular letter. She was not aware of it. So that is post facto, when they've already dumped these snippets for the intended documentary. Then now the second one of the distorted events is the letter of the 8th of Jan. The letter of the 8th of Jan is used to try to then to create a picture as if like this agency was triggered from the 8th of Jan. Therefore, Dr. Magudumane stayed supine and only approached this court in September. That is far from the truth. The letter itself My lady, can I be given indulgence to just locate the letter of the 8th?
Certainly.
I'll come back to it. I'll just explain what then transpired on that particular letter of the 8th of Jan. The letter of the 8th of Jan came about. The letter of the 8th came about under the following circumstance. The instructing attorney now for this matter informed Mr. Machini that there are rumors that Netflix is going to broadcast the documentary, which, according to the agreement, they are not supposed to broadcast if Dr. Magudumane has not been given a chance to comment and do all other things that they've confirmed in their letter. My lady, there's no page reference. I don't want to derail the court, but
No,
it's there.
I've got the page reference.
Yes. Then it says that, dear, good day, Laura. I trust you are well. I've been informed by Thabo Besta's legal team that there's a clip doing rounds involving documentary in which Dr. Magudumane's father is being interviewed. I'm told the documentary session will be shown on Netflix by the end of Jan. The said legal team furthermore indicated to me that there's a payment of 1.2 million affected to me by yourself in respect of this documentary. I have the following serious concern regarding the above. The recording of Dr. Magudumane's father without his legal team giving permission on the content is prejudicial in many respects. We respectively requested that an interview that is to be conducted in the name of our client should first receive our consent, particularly to the content of such interview. We respectfully requested and agree that no part of the documentary should be shown before our current legal case involving our involving our client are finalized. We specifically agreed that no part of the agreement should be disclosed to any third parties. Then, this is then followed by a complete denial that that documentary is going to be broadcast through the letter on the 3rd of Feb. It's a direct response to, I've heard that this is what you intend to do. The response, I hope that you are doing well. I'm sure that you have a lot, page 001-115. I'm sure that you have a lot on your plate with the trial coming. We have a bit of difficulty responding to your letter as we are bound by confidential agreement signed with different parties, as you will appreciate, and it's not clear from the email whether it relates to Ms. Magudumane or Ms. Fesikeleni. That said, I can comfortably give you the assurance that there is no truth to the statement by Mr. Bessa's legal team. What is the truth and untruth of the statement? Is that you want to publish? They completely deny. Now a statement is that the trigger agency is that particular time. When we sent a letter, we should have come to court when they deny what we are saying. That's the trigger agency. Remember, this is done now to elevate this argument when it goes to cost. Because this elephant, this is unthinkable. A party who was supposed to come in Jan is here in September. Unthinkable. It's an abuse of court process, lack of courtesy. You must address those submissions based on the papers. You must then say that we didn't explain reasonably, we disregarded. 612, you ask for deviation and then you explain the deviation. The deviation does not mean disregard. The disregard is when the explanation is not sufficient. But you can't make submission in the air. You must make submission to the explanation that was given, and you must say it's unreasonable. But there's a starting proposition that is made that if a person is incarcerated and there are challenges that they face in seeking legal advice and attaining such, they cannot use that as an explanation that I heard about this particular aspect, I needed to have a consultation, I had a consultation on this particular day. They say that no, they cannot come and for those limitations, they are barred. That's the sum total of the submission. For thus, if they know that there's limitation, they cannot even invoke Rule 612. Rule 612 is invoked for that, to explain your peculiar circumstances. What are your circumstances making you not to comply than this other one? And that's why we have these different cases between Dr. Magudumane and Mr. Bester. You will find, my lady, at paragraph 108 of the founding affidavit, you are told that there's a practice directive. We know the practice directive by Thursday noon, papers should be ready. If they're not ready, what must happen? You don't come to court, you do. You do. You explain why you could not file the papers by the previous Thursday. The rule is not, if you skip Thursday, you have traded your rights. The rule is that if you can't, or if you could not, then you explain it in your papers. These are the papers. Paragraph 108 of the founding affidavit. That is explain why such practice directive was not complied with. And you will see that at 00142. She says that the fifth, my lady, when the parties reach loggerheads, when Netflix, after having asked extension to consult with their lawyers, came back with an answer that we're not engaging further. The fifth is Friday. Cannot reverse it to be a Thursday. When is Netflix broadcasting? Tomorrow. Is there any other Thursday before tomorrow? No. It's actually Thursday today. So, you follow that line of reasoning, we should have then filed the papers today. Netflix publishes because we want to be bound slavishly to the rules or the directive. That argument, obviously, it lacked legal cogency. Then, the case law that we rely on, I won't read, it's Mogala Kwena at paragraph 12 of the heads and Grace Venu. I've said in my main arguments, you look at the reasons why this matter was delayed and is prosecuted in this particular aspect. And then I said to this court, at every point, Dr. Magudumane, even from the consultation, not before she even lodged these papers, she kept them abreast. After they responded on the 31st of August 2025, the instructing attorney says that we've only managed to secure a consultation on the 3rd. We can't respond. We will respond to the response after the consultation. And then she does that. She was supposed to come blindfolded without having attained necessary instruction from Dr. Magudumane. Because this court, because it's busy, you cannot ask for deviation. That submission, my lady, I submit that it should be discarded on the facts that is before the facts that are before you. Then there is then the issue of reply unsigned in all that. That is when the respondent sent the answering affidavit for the first time, it was unsigned because they understand that you don't have to delay and wait for it to be signed. Give your opponent so that they can be preparing. The signing, you're not going to change it. But at least the substance, give them the time. That's why they operated. So they say that they have a right to do it, but we can't do it. We send to you because it might be delayed in the commissioning. So that cannot be said that it is not good reason. Then the last aspect is that in respect to disregard to court rules, which is not disregard, it's a regard, not disregard. She regarded the court rules. After having received the answering affidavit, in the reply, she told them that, the instructing attorney, that I received the answering affidavit, Dr. Magudumane need to see it, I can't respond. She only managed, and it appears in the replying affidavit, she only managed to consult with her for 30 minutes. And at that time, she had made arrangement with the correctional service to bring the answering affidavit to the attention of Dr. Magudumane. To her surprise, at 11 a.m., where the consultation was arranged telephonically, she learned that Dr. Magudumane does not have an answering affidavit. But nonetheless, because of the exigency of the matter, she gave an overview of what this case is about in terms of the answering affidavit so that she can get necessary instruction. And she says that we had to improvise. And you're telling that you're disregarding the rule. Because if you look at the papers, you can then summarize to your clients that this is what they are saying, this is what they are saying. You have anything to say. I might not go seriatim looking at the time constraint. That's why you look at the replying affidavit. It's addressed thematically, agency and all that. So to the extent that what is said in the founding affidavit is at odds with the reply is denied. That's how it went. Then, furthermore, after filing the reply together with the heads, she explained in the further explanatory affidavit. And you'll find, my lady, the explanatory affidavit, it says 006-1. And it's just one page. This is someone who's accused of disregarding the court rules. She's explaining what happened. You must punish her for explaining. It's a catch-22 situation. Paragraph 5, it says the following. I have dealt with the challenges faced by the applicant regarding accessibility and taking instruction. That was dealt fully in the founding affidavit and the reply. As a result, even the preparation of the replying affidavit was done through improvisation, in that I had to summarize the respondent averments in the answering affidavit to the applicant, as she did not have the answering affidavit with her during our telephonic conversation. This resulted in the late filing of the unsigned replying affidavit, consequently the heads. As a result of the above, I'm seeking condonation for the late filing of the replying affidavit. There are typos and heads of argument as prescribed by the AJP directive. So there was a directive given specifically that parties must exchange all the papers by 4, including the heads. So she is not disregarding, she is regarding it, she is acknowledging it. And she says the following. The applicant was not willful. She had to deal with answering affidavit excluding answers of not less than 60 pages, answering affidavit, and challenges she faces. The delay in the filing of the reply and the heads was not excessive. It's less than 24 hours. The applicant has a strong prospect of success in obtaining the relief. I've demonstrated that that contract in terms of the Constitutional Court says that it will not have difficulty. So this is the explanation. It is not being controverted, but an argument must be made in the air because it's legally attractive. A legal argument that is attractive without facts is of no moment. Then now, we then deal with the issue of Section 9. I think that will be the last aspect if I did not forget anything, because these notes now. So now, you look at this aspect of courtesy. When they're saying someone doesn't have courtesy, I'll just make a reference. At page 001-142, that's a letter of September before the application was lodged, just telling them that I'm not sitting, I'm waiting for the consultation. I was just giving the reference to that particular aspect. So the courtesy even begins before the litigation. And then it continues throughout the litigation until we get to court this morning. She keeps on abreasting them. Then now, the final aspect, Section 9. You look at Section 9 with the engagement that we had, and my learned colleagues respond regarding Section 34. I'm failing to make sense out of it, but let me try. It's an attempt. You have a contract that says that you can approach the court. Because you are seen in court, therefore that contract does not exist. That's not how you must argue in court. You can't be blocked by the security because of Netflix blockade contract. When you are here to set it aside, it is that you can then access other rights. Because if you can't set it aside, then it says that you have waived your Section 35 right, you have waived any right except for claim for damages. That is exactly why we're saying that this is dangerous about this particular contract. Because I'm seen standing here, extended screens, then Dr. Nandipal's clause blocking air has vanished into the thin air. Because I'm in court. We're in court to then say that in Part B it must be set aside and there's a strong case. And then they told you that you don't go to court because you are blocked by the contract. But when they come to court, Section 16. That's malicious litigation. You change like Cape Town weather depending on what will fit the argument. Then I close by what I started with. Krickler. Justice Krickler. And there was no meaningful response to that particular aspect. My learned colleague has assisted. So that I won't read it, it has been read. Why am I ending with it? because all of the things that we've said, they fit specifically to the issue of prejudice. It's not only prejudice in court. There can be prejudice by public trial, and the reliance on the bail application. You are told that we are not kids. That means we are adult. It's a legal principle. If you follow that principle, Thabo Bester is guilty, adult principle. Dr. Magudumani is guilty, adult principle. Any other principle except the principle that has been agreed by the parties that she has the right to comment, bail application. Bail application is not making a determination of guilt. It simply says that test for bail is that it should be in the interest of justice for the accused to be released, and then there must not be a flight risk. The state can then demonstrate that they have a strong case.
I know what a bail application is. I think you misunderstood the argument. So it's public what was the assertions were, and therefore the argument is it's not something new that's going to be an ethics.
There were two arguments.
There's nothing about an adult and therefore you guilty.
There were two arguments that were made to that respect. There's the issue of being public, but also the issue of fact. When an argument is made that Thabo Bester or Dr. Magudumani are guilty, it's a statement of fact. When you say that it's public, you are saying that obviously it's public, but you were asked to then say that there are findings that are made. So there were two submissions to that. So I'm addressing the second one. I'm not concerned about this being public. It's not Dr. Magudumani's father being interviewed to testify. It's something else. It's completely differentiable. And I will end that submission there, my lady, and I'm saying that that means in respect of cost, I don't think that we even get there to the issue of de bonis with the evidence that you have of the explanation. I don't think we even get there, truly speaking. And I would not waste the cost time by answering to something that is not supported by the facts. The facts were there. We then say that it doesn't reach to that state of multing a practitioner who took reasonable steps and explained herself at every point, as the court pleases.
Thank you very much. May I just find out when is this? I'm not asking you, I'm asking counsel. When does this flight, or when does it show?
I'm told, but actually let me ask before I give evidence.